The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. People versus Leticia Fisher, 5 and 1 for the appellant. For the respondent, 5 minutes. Grant versus the City of New York is submitted. See Children is submitted. Salmon versus Roosevelt Island for the appellant, 5 and 1. For the respondent, 5. Ramirez versus Selective Advisors for the appellant, 5 and 1. For the respondent, 5. Carlson versus Chelsea Hotel for the appellant, 6 and 1. For the respondent, 6. Ramirez versus Handsome for the appellant, 5 and 1. For the respondent, 5. People versus Mario Guzman, submitted. DeLuca versus Hafen Capital Holdings for the appellant, 6 and 1. For the respondent, 6. Cirrus Inc. versus Katz for the appellant, 5 and 1. For the respondent, 5. Family Health versus Rowan Developments for the appellant, 6 and 1. For the respondent, 6. Arisi versus Puma for the appellant, 6 and 1. For the respondent, 6. People versus Michael Hill for the appellant, 5 and 1. For the respondent, 5. Polikoff versus New York City Department of Buildings for the appellant, 5 and 1. For the respondent, 5. Leonard versus Ames for the appellant, 6 and 1. For the respondent, 6. Emigrant Bank versus Rosa Bianca is submitted. Lopez versus Mama's Fried Chicken is submitted. 1591 2nd Avenue versus the MTA is also submitted. Counsel, I'm just going to ask that you please remember, as always, that we have your briefs, we have your record, we're fully familiar with the facts of your case, so please go directly to the most important points that you wish to make. Also, as is customary, please don't speak when a justice is speaking, and this is particularly important, of course, in our virtual arguments in order to hear the questions that are asked. And finally, please keep your mics muted until your case is called. Thank you for your patience and your cooperation. We are ready for number 1, which is People versus Leticia Fisher.
Hello, Allison Haupt on behalf of Ms. Fisher. May it please the court. The sentencing judge in this case, Judge Caro, who was intimately familiar with the facts of what happened as well as with Ms. Fisher's background and history of mental illness, he believed that the 18-year sentence imposed in this case was too harsh and severe. He was right. It is, and that is why we are asking this court to exercise its authority to reduce her sentence.
Counsel, let's talk about the waiver, because we can't reduce unless there's a waiver that's ineffective here.
Right.
What are the infirmities of this waiver?
So first, respondent hasn't actually challenged the waiver here. The issues with the waiver are waived by respondents, and I think by their admission, it's not a valid waiver. For reasons that the courts have rejected this waiver on numerous occasions for claiming that this is a complete bar to an appeal, that completely invalidates the waiver, which respondent does not disagree with. So there's nothing barring this court from taking the action that Judge Caro is really asking for this court to take. He made it clear at resentencing that he believed that a reduction was appropriate here. And it's because he recognized that Ms. Fisher is less culpable and therefore undeserving of such a harsh sentence. A sentence that I'd add that respondent's office is now saying it's close to the maximum of what it'll ever recommend in a determinate sentence. Certainly those maximum sentences more appropriate for someone incorrigible and unforgiving and not a mentally ill, grieving, devastated woman.
The minimum here is 15 years. Isn't that right? And that's 3 years different than what she was sentenced to. Is that right?
The minimum here is 10 years, and so there's a significant range less than what she was sentenced to. She was sentenced to 18 years, but the court could actually go as low as 10. And I think that that would be appropriate in this case, given all that we know about what happened here. That Ms. Fisher is suffering from a serious mental illness is well established by this record. Judge Caro had before him 5 different medical professionals diagnosing with her with an illness involving psychotic features. And I don't want to belabor the point that there's so much evidence supporting those diagnoses. He clearly thought that it was the essential factor in Gabriel's passing.
And was that psychosis due in any way to any kind of drug inducement over time?
No, Your Honor. Actually, it's important to note the record shows numerous toxicology reports showing that she did not use any drugs at these times. So that was weeded out as a possibility for this sort of behavior. What they were observing were the clinical manifestations of psychosis, anecdotal evidence from family members, even ex-boyfriends talking about psychotic behavior. This was extremely well documented as being a mental illness and not used due to drug use.
So this person is completely in her state because of mental illness. There are no other factors other than that she was a mentally ill person who hadn't been appropriately treated for her illness, or
it appears so she was receiving treatment that she had been doing quite well in, something again that Judge Caro thought justified a reduced sentence, but was not medicated at the time. The record shows that she believed that she was pregnant and had gone off of her medication. Records immediately after this incident say to restart Risperdal immediately after a pregnancy test. And so it was during a period in time when she wasn't getting the full scope of the treatment that she needed in order to manage her illness. But Judge Caro commented on how well she does when it is effectively managed.
Was there ever any instance was there any demonstration that she had ever mistreated the child? Ever?
No, and that's such a wonderful point. The record shows what an incredibly loving and attentive mother she was. Gabriel's father, Luis Ortiz, described how they were always together, always playing, and that when the baby was playing with her, he was happy. Social workers, family members, neighbors, all of them commented how she was patient and loving and how happy the baby was. And so in cases involving fatal maltreatment and neglect, you would expect to see that sort of evidence. The record doesn't show any of it. What it shows are the classic signs of when this sort of incident occurs because of mental illness: a history of hospitalizations, continued outpatient care, suicide attempts, immediately owning up and admitting to what happened. Those are all evidence of when this occurs because of mental illness. There's no evidence to support fatal maltreatment or neglect. And I think that that's such an important reason why Judge Caro believed that this sentence was too harsh and severe. And certainly this court has repeatedly reduced sentences when they've seen evidence of this sort of extreme mental illness. It's happened in numerous cases, and this case really pleads for it, especially because we see how well she can do when she's getting the treatment that she needs. She's doing remarkably well in prison, no disciplinary tickets, taking college courses, working with the chaplain who says that he really hopes she gets out of there. Certainly he's been exposed to a wide variety of people, and he singled her out as worthy as having a second chance.
Thank you. Let's hear from counsel. Your time is up.
Thank you.
Good afternoon. May it please the court, Jennifer Westwell for the people. I would like to just begin with saying it's great that the defendant is doing well in prison when she is medicated. And
I'm just going to ask you to speak to the waiver.
Of course.
Do you any challenge to what counsel has said with regard to your position on the waiver?
We don't concede that the waiver is open to challenge. However, given the competing cases in Tausinger and White, we just assumed for the sake of argument that her right to appeal her sentence as excessive survived her guilty plea. But we still maintain that it's clear that her sentence reduction claims are meritless. I would just like to turn to...
I think what you just said is that you're not challenging with any legal evidence,
Yes.
any cases, what she said. Okay, you can move on. Thank you.
I just want to look at the sequence of events when she was leaving cases and before Gabriel's murder. She said that she thought she was pregnant. She took herself off of her medication without the consultation of doctors. And she said that she began to experience symptoms. But defendant's own resentencing memorandum points out that she was very guarded and she was reticent to share with the case's team what she was experiencing. And that's
Let me ask you, is there any evidence that she was a drug addict or that this mental illness was due to years of abuse of drugs or anything other than this is an individual who is purely suffering from mental illness?
No, I don't believe there's any evidence of drug usage or anything other than her mental illness.
Was there any evidence that this defendant ever abused this infant?
No, Your Honor.
Was there any evidence that she was anything other than completely remorseful for either the incident with her aunt or this incident?
No, there's no evidence that she was anything but remorseful, but I think she was reckless with her condition. To take herself off of her medication and to go back out on the street after she had violently assaulted her aunt, and then ultimately leading in Gabrielle's death, I think is reckless. And it's with her, the full understanding of her psychological background and her personal background, that we made this defendant a plea offer that
Counsel,
removed the possibility.
So this is Judge Rodriguez. I'm going to ask you a question. How are the circumstances in this case any different than in People versus Jeffries, where this department in 1990 it exercises discretion and reduced the sentence there? And in that case, that involved 2 convictions for manslaughter in the first degree, where the defendant killed both of her daughters, ages 8 and 4.
I have to apologize, Your Honor. I'm not fully conversant with that case. If you would like, I can submit a letter to the court after argument, but I feel I can't address that currently.
That's fine. You may continue.
Thank you. With full consideration of this defendant's psychological and personal background, we made this defendant a plea offer that removed the possibility of a life sentence and a murder 2 conviction. Defendant accepted this offer. Gabrielle's family has relied on this disposition. At the time of sentencing,
Counsel, this is Judge Scarpula. I just want to make sure that my understanding is that the sentence could have been 10 to 25, correct?
Correct.
So this is just about in the middle of that?
Yes.
Okay.
Yes,
And do you know why the prosecutor would not accept Judge Caro's recommendation to go down to 15?
Given our resentencing letter, the prosecutor at the time stated that we had made this offer with the consideration of defendant's psychological and personal background. We believe that those mitigated her offense, but even considering that mitigation, we came to the number of 18. So that was already taken into consideration, and we weren't willing to go lower.
And she had already been convicted of stabbing and tasering her aunt.
Yes.
While off medication and
Yes.
during, I imagine, a psychotic incident, correct?
Yes.
Okay.
And the subsequent court supervision of her in the cases program proved ineffective, because very shortly after she was transitioning out of cases, she took herself off her medication, and we wound up in this sequence of events resulting in Gabrielle's death.
And just to be clear, she took herself off of medication because she believed herself to be pregnant and that the medication would harm the baby?
Yes, but she still 5 months
I understand
later,
she didn't check with her doctor first, but that was her reasoning. So
That was
it's
her
not to
reasoning.
harm the baby. She took herself off of the medication?
Yes, but she let that rock for 5 months. Gabrielle's death was 5 months after she was allowed to replete. So if she believed that she was pregnant,
Didn't she have, I mean, she had the baby, so there was an interaction with medical personnel. In other words, she took herself off of medication before she had the baby because she thought she was pregnant. So there, is that not?
Are you speaking of Gabrielle or another baby?
No.
The end of cases, she had already had Gabrielle. So when she took herself off her medication, that was 5 months before Gabrielle's death. Gabrielle was 20 months old at the time of his death.
Wasn't she interacting with? Never mind. Go ahead.
I don't believe so, Your Honor. I don't think she was actually pregnant.
Well, counsel, if I may, I think what Justice Drengo was alluding to was that she took herself off of medication twice before when she thought she was pregnant, and in those 2 instances, she was in fact pregnant, correct?
I don't think so. Or I don't know, Your Honor. I have to go back and look at the record. I just know the time period between, I'm assuming she was off it for Gabrielle's birth, but I don't know whether she took herself off or she went to a doctor for that. I just know towards the end of cases, she took herself off because she believed she was pregnant and did not put herself back on by the time of Gabrielle's death. If there are
Thank
no,
you.
Thank you.
Thank
I
you,
request you
counsel.
confirm.
If I may, I would just point out that Judge Carroll said that he believed a reduction was appropriate here because of the extent of her mental illness and the way that she was able to succeed when doing well in cases. He never said that the reduction should only be to 15. He left it open that it could be lower than that, and this court can go as low as 10 What he said was that if he were to resentence her on the murder too, he would do the minimum of 15 to life. And so he did not limit it to the 15 years. And I think that for reasons that we've discussed, there are so many reasons to justify her reduced sentence. And we know that.
And she has been in since when? She is credited with time since when?
Since the incident. She was immediately arrested.
2015 or something else?
Correct, yes. And certainly, as Your Honor noted, these issues started when she believed that she was pregnant. She had gone off of her medication when she was pregnant with Gabriel without incident and believed that it would be okay to do that as well to keep the baby safe. She ultimately was not pregnant, but thought that she was. And so certainly no matter when she's released, even at a decades-long prison sentence, she's going to be well past childbearing age. This is not a type of situation that would repeat itself.
How old is she? Since you mention it, how old is she?
I believe she'd be, I don't know, currently right now, she'd be like in her mid-40s by the time even a decades-long sentence would be done, I believe. I did the math the other day and don't have it in front of me. So this is not the sort of situation where it would repeat itself. She is punishing herself so severely. There is truly no harsher sentence than the one she imposes on herself. I encourage you to read her poetry. I think it shines such a light on who she is and how deeply remorseful she is. And so we ask you to reduce her sentence.
Thank you. Thank you both. Jennifer Salmon versus Roosevelt Island Operating Corp.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiff appellant in this case. It's the plaintiff's position in this case that the defendants did not meet their prima facie burden in proving whether or not they had constructive notice of this missing sign that was out of and left a base in the crosswalk on Roosevelt Island.
But counsel, Mr. DeJoseph, is there sufficient notice here?
Well,
let me just be more specific. Is there specific notice to the defendant where the plaintiff just testified that the day before, which is just 24 hours at best, the sign was intact?
Yeah,
and the witness who submits the affidavit submits that affidavit in reply, I think, or on appeal. It wasn't an affidavit that was submitted below, and it says 8 hours.
Okay, Judge, let me do a reset. I did not consider that affidavit at all in my appellate argument in my brief. Has nothing to do with this case, and the defendant keeps bringing it up.
Then let's take it out. Let's talk about your plaintiff's testimony about the day before she had passed the sign, it was okay, and then she fell the following day. That's 24 hours.
24 hours.
With that. So my question is that an appropriate amount of time to have the opportunity?
Absolutely, especially given where this defect is located. This defect is not on some step in a stairwell in a housing authority project. This defect is on Main Street of Roosevelt Island in the middle of the crosswalk where literally the witness for Roosevelt Island stated at page 203 of the record, anyone can see it.
No, but counsel, but how does that affect constructive notice? Constructive notice is the issue where it happens all the time. You should have known. This is one of those things that recurs. You can't have constructive notice simply because the event happens.
Judge, let's not confuse recurring condition with constructive notice.
So what cases are you showing to us that say that someone would have of a signpost constructive as opposed to actual notice? I mean, we have tons of cases where stop signs come down, things like that happen. I couldn't find any that were close to yours. Close to the time period in this case with these circumstances.
Let's not also, this is not the city of New York.
It doesn't matter. It's still the issue. I mean, it's the same situation. It may be a private property owner as opposed to the city of New York. But the question is, what have you got to show constructive notice?
I don't have to have any. You see, we're reversing it. This is a summary judgment motion, not a trial. I don't have to prove I have any notice.
So the defendant puts in an affidavit from its chief guy who says, I didn't have notice of this. On Friday when I left, it was good. No one that we circle around during the weekend, no one saw it. So let's assume that the defendant made their burden with that.
Judge, that
doesn't even make their burden.
This is not a hypothetical. That's not what they said. They produced one witness. The one witness said, I was there Friday. I never saw it after that. And then they produced no evidence from anyone whatsoever as to what happened between Saturday and Sunday. There's nothing from the public service officers. There's nothing regarding their inspection schedule. There's nothing from the maintenance department, nothing. So that 24-hour period, there's no inspection, no cleaning schedule, no mention that we were there, the sign was there an hour before the accident. And this is a sign that is in plain view of anyone. And the testimony is that the Public Service Department patrols this area 24 hours a day, 7 days a week. So at some point in time, there's case law that says, hey, when you're in the vicinity of where there's a defect, you are bound to see it. Those cases are cited in my brief. Rose in this department and Canizaro in the second department. So that the defendant here just did not meet their burden. Doesn't mean they're going to win that at the trial I can prove constructive notice, but what it does mean is that you can't just award summary judgment because the case doesn't, because you point to a gap in the proof at the time of the summary judgment motion. That's just not what the laws are. And that's the position we took, forgetting about that affidavit, because I did not rely on it in my brief. Didn't want to get into that.
Okay. Thank you, Mr. Joseph. Let's hear from opposing counsel.
Thank you, Your Honor. May it please the court, Ross Massler for Respondent Roosevelt Island. And I would just repeat, I think, what Judge Scarpula had said earlier. This is a case, this isn't a case where this sign was missing for 24 hours. We know it was there.
What about what Mr. DeJoseph says, that you have the security, not the maintenance, but the security for the Roosevelt Island, patrolling it 24/7 just for safety reasons. And everyone says this was obvious. It is in the middle of the street where it's missing, where that for safety purposes, you'd want that for the traffic, so the traffic would stop for pedestrians. Isn't that something that they would have had notice of then?
If the sign was missing, potentially they would have notice of it, but there's no evidence of that here. Plaintiff was there the day before, and the sign was there. The testimony is that this is not something that is foreseeable. It happens once in a blue moon, according to the maintenance supervisor. If the safety patrols are there and they're driving past, the sign was there. That's why they didn't make any statement as to what happened there. There's no testimony that there was ever a situation that this could have happened in the seconds or minutes prior to plaintiff's fall. The testimony is that if it does occur, it occurs because a car comes by and hits the sign and knocks it out of the crosswalk. It could have happened seconds earlier. This court has said, they said a year ago in Ellis, landowners aren't required to patrol their property 24 hours a day. That's not the law in this state. Okay. In Basso versus Miller, the Court of Appeals said you have to look at foreseeability. The standard of reasonable care on a landowner is foreseeability. And here, it wasn't foreseeable that this would occur because it didn't happen at any kind of a regular basis. It was completely unforeseeable. It happened once in a blue moon.
I'm sorry, just to be clear, your argument, though, is lacked as a matter of law that you neither created the condition nor had notice thereof. Foreseeability now, we're kind of bleeding over into other elements of the negligence claim, correct?
Well, absolutely. Our claim is that there's no constructive notice here because there isn't any. Plaintiff herself candidly admitted she saw the sign really less than 24 hours earlier when she crossed that street. I'm making the point that the broader question of foreseeability, I think, is in fact a factor here, given the fact that this is not something that occurred on any kind of a regular basis. The maintenance supervisor, plaintiff's counsel is incorrect in saying that we didn't present any evidence as to our inspection schedule. The maintenance supervisor testified that he inspected it on his way out the door on Friday afternoon, and the sign was there. So we did present evidence of our inspection schedule.
Yes, I
this
think
is a
he
clear
was
case.
speaking, I think he was speaking also to the security. Maintenance, definitely, that is in the record.
Well, but there's no, as far as
I don't
I
want
know.
to speak for Mr. Joseph. He's certainly going to speak for himself. But
He
I thought
certainly will.
that's what he
He
said.
certainly will, and he does well. Okay, I think I've made my point that it's clear that there is no constructive notice here, given the fact that we inspected the property 48 hours earlier, the sign was there. Plaintiff admits that she was there less than 24 hours earlier, and the sign was there. This sign could have been struck by a vehicle in the seconds preceding plaintiff's accident. That's not enough time to establish constructive notice. I would ask the court to affirm the lower court order.
Thank you, Mr. Joseph.
Yeah, counsel makes out my case for me, because what he tells you is he's testifying. They needed to produce a witness from the security department to say exactly what he's saying now. Yes, I was there an hour before and I saw this sign and it was there. But that's not what this record has in it. It has this vacuum of 24 hours where no one says anything about whether the sign is there or not. And 24 hours is ample time for constructive notice. So here, the defendant just didn't meet its burden. What it would have needed is
Counsel, this is Mr. Joseph, this is Judge Scarpula, except they did submit your client's affidavit and her deposition testimony where she said, you know, there was the guy who said he inspected before he left, and she said it was there the day before. So you're saying that they were required to patrol every 20 minutes or 20 or an hour and a half? Where does that come from?
Your Honor, I have never said anything of the sort. What I'm saying is.
So again, then where does the constructive notice come from?
Your Honor, the defendant has a public service department. They patrol this street. All they had to do here was put in an affidavit the same way they had the witness testify from the maintenance department that I was there 10 minutes before. I was there an hour before, and I wouldn't have this argument available to me. But there's a fundamental lack of proof in the defendant's case here, and it's there, and we're just not acknowledging it because we don't think the plaintiff can prove their case, so we want to toss this case. And that's not how the summary judgment works, unfortunately. Now, I'm older now. We didn't used to toss cases like this back when I was a kid. Now this kind of a case gets thrown out when the defendant clearly hasn't met their burden. That's what my argument is. And nothing to do with foreseeability. Okay, I don't even know how that came up. Thank you.
Thank you, Mr. Joseph. Thank you both. Ramirez versus Selective Advisors.
Yes, Your Honor. Good morning, good afternoon. Juan Ramirez on behalf of myself, may it please the court. My petition seeks to vacate a judgment by confession signed by the clerk of the Supreme Court based on 6 pages. Those 6 pages can be found in the record from pages 44 to 49. And if you look at that, 2 things jump out at you. Number one, that the affidavit confessed to a judgment to torts of fraud and abuse of process. And number 2, that Raymond Hu, as manager for plaintiff, signed the affidavit of confession pretending to be the defendant, NLG. These 2 facts alone render the judgment void ab initio, and you would not need to reach the constitutional issues raised in this appeal. The Confession of Judgment Statute, CPLR 3218, authorizes entry only on a debt. The statute clearly states that a defendant may confess to a judgment for money due or to become due, stating concisely the facts out of which the debt arose and showing that the sum confessed is justly due and to become due.
Counsel, in this case, the court, the relief that was requested was to vacate the default. But what happened was there was a dismissal here of the case. Isn't that right?
That's correct, Judge.
And right. And so there was an appeal from that dismissal, but that dismissal was a sua sponte dismissal, right?
No, Judge, we had a motion on behalf of the defendant, and we had an oral argument and a hearing on that motion. And I was prepared to defend the service and the vacator of that of the judgment from 2012. But the judge went further when he vacated the prior judgment, and then he decided the case on the merits.
Right. But the vacature of the complaint was not in the motion. That wasn't requested. That was sua sponte, correct? And now the case is dismissed.
Correct.
That was done sua sponte, right? And it's that which is being appealed.
I was not prepared at the hearing to argue a dismissal. I was prepared only to what was teed up was the vacator of the prior judgment.
Right.
But in their papers, the respondent said that the judge could decide the case on the merits because everything they needed was before it. This is strictly a paper case, so we can jump to the merits of the case. And
I guess what I'm saying is there's no appeal as of right from a dismissal that wasn't by notice of motion, that was sua sponte by the court. I don't know that there's anything on the record that they asked to conform the pleadings to the proof and change this to a notice of request anything formally. This was just done, and you, as you just said, were not prepared to speak to that. So it was just done sua sponte by the court. But now we're asked to, that's what's being appealed here, obviously.
Well, Judge, at the argument, they did, when the judge intimated he was going to dismiss, they did argue for the dismissal. I don't understand what your issue is. I'm sorry. I'm from Florida. I know Florida procedure, but I'm not as familiar with New York procedure. This is a case which the court dismissed, and I think it was wrongfully dismissed because he got into the merits of the case. Once he decided he had no jurisdiction because service was improper, how can you then decide the merits and dismiss the case on the issue of standing and on the issue of res judicata? You cannot, in my view, decide the case on the merits without giving the parties notice and an opportunity to be heard. The case, it's a paper case, and we've been trying to get to the merits.
Did you do a motion to re-argue?
Yes, we did, Judge. We did do a motion to re-argue, and he denied the motion to re-argue, and he rejected all the arguments made in the motion, including the fact that if he had no jurisdiction, how can you then decide the merits of the case? Because that creates a problem for us if we refile the case. I think the proper remedy would have been to vacate the judgment that he entered by default and allow either to reserve or then go on the merits of the case and decide whether this was in fact a proper judgment. And I think it's patently void on its face because it was not served on the defendant, and it was based on a statute that wasn't complied with. So they skipped over all the niceties such as service of process, opportunity.
And you moved to dismiss, and you moved to vacate the dismissal before the judge. You moved to vacate the dismissal.
I did, yes.
Okay. Any further questions? Let's move on to opposing counsel.
Good afternoon, Your Honors. My name is Paul Golden. I'm representing the respondent in this case. Am I audible?
Yes.
Okay, wonderful. So one of the critical issues here, of course, is that it was the underlying petition was improperly served. There's really no dispute about that issue. My adversary has admitted in his brief, he's admitted it for all intents and purposes before. Yet, almost amusingly, he's seeking within the context of this appeal not only to bring his petition back to life, but he's also asking for complete relief. Of course.
Well, do you dispute what he said about having moved to vacate the dismissal order?
I didn't quite understand what he meant by that. He made a re-argument motion. If maybe I'm not understanding what the question was.
No, you're saying he moved to re-argue, but he didn't move to vacate the dismissal.
That's right. He only moved to re-argue. And what's critical in what Your Honor was talking about was that for all intents and purposes, my adversary has admitted that aspect of the case which dismissed the petition was sua sponte. I believe he's for all but admitted that just a few minutes ago. That being the case, this court really doesn't need to go any further. Mr. Ramirez, for whatever reason, decided he did
Ramirez.
not.
Mr. Ramirez.
Ramirez, I mispronounced it. Did not file the appropriate motion for leave to appeal. This court could have decided whether it was something that could be appealed or should be appealed, I should say. But Mr. Ramirez decided not to go that route. He only decided to re-argue it. This court doesn't have the power to hear whether the sua sponte decision was appropriate or inappropriate because he failed to make that motion.
Any questions from the bench?
Okay, I had a few more comments, but I leave it at your discretion.
Okay, if you want to make them, you can. Otherwise, we'll move on.
Just a few more comments. Is that the underlying judgment at issue was already marked as satisfied. There is a case called HDI Diamonds case, which was a First Department Appellate Division case. And that case has never been overruled by this court, which indicates that once a judgment is satisfied, you can't go back and try to argue that the judgment should be vacated. My adversary said, well, there's a First Department case which cited a different case which seemed to conflict with HDI Diamonds. What he was actually citing in his reply brief is a First Department appellate term decision, not a First Department appellate division case. I also have the arguments in my papers about how the statute of limitations, the court was right to dismiss this case ultimately because of the statute of limitations issue. The issue here is that many years after the judgment was issued, he comes back and says he's a creditor.
We know the facts, so please don't go back over those.
Fine. I'm not, but the problem is if someone can keep going back and saying, well, I only became a creditor less than 6 years ago, so let me come and vacate that old judgment. That means 10 years from now, 20 years from now, 100 years from now, someone can keep saying that they're a creditor and keep arguing this, which means
your time is up, so wrap it up.
Those are my primary arguments, Your Honor. Also, my arguments are that he was in privity with the previous parties that were unsuccessful in getting the judgment vacated. If there's no other questions, I'll rest.
Thank you. Go back to you, Mr. Ramirez. You're muted. You're muted.
Sorry. In People versus Quadrado out of this court, it said that want of jurisdiction makes the order and judgment of the court and the record of its action utterly void and unavailable for any purpose. So the issue of a void judgment may be raised at any time, and the case law is abundant on that. There's no statute of limitations when you have a void judgment. The fact that the judgment is satisfied, the case law is clear that if the defendant did not pay anything on that judgment, you can still challenge the judgment. It's only when the plaintiff, when the defendant pays the judgment and then tries to challenge it, that they're barred. But in this case, it is undisputed that NLG has never paid anything on that judgment. So the fact that it was satisfied unilaterally by the plaintiff does not prevent us from challenging the vacator. Judge, it is clear that Justice Bork was not going to grant us relief. We went back to him with a motion, and he denied it in all respects. And in fact, he sanctioned me for filing the motion in the first place, because he said it was so frivolous. So we're trying to tee up the merits of this case. The merit is clear that a judgment on a tort cannot be entered by confession. This is a case where the plaintiff himself signed the affidavit for the defendant, and he cries for justice in this case. It's the $5 million at stake, which the plaintiff just picked out of the air because there had never been any litigation between these parties before that.
Thank you.
I urge you to reverse and remand.
Thank you. Thank you both. Gretchen Carlson and Philip Taffy against the Chelsea hotel owners, et al. Are the parties there?
The appellants are here.
You begin.
My name is Mitchell Haney. May it please the court, I represent the appellant's tenants who are the plaintiffs in this case. Gretchen Carlson and Philip Taff. As your honors know, on page 19 of respondent's brief, respondents concede that the second and third causes of action in the complaint should be reinstated and remanded to the lower court. Hence, I'll address the contested issues on this argument. Specifically then, as to the first cause of action, which pertains to respondent's argument about pleading violations of record. There are two flaws in respondent's argument. The first flaw is the actual language of the statute. And the second flaw is that on this CPLR 3211 motion, not a 3212 motion, the court refused to accept the appellant's allegations as true, liberally construe them, and accord appellants the benefit of every favorable inference as to them, as occurred with the allegations in the Job case that is cited in our brief, which also pertain to these respondents. This is the defective basis upon which the court found that the allegation at paragraph 29 of the complaint, which is in the record at page 63, was insufficient. This allegation was that respondents, quote, have repeatedly failed to correct hazardous or immediately hazardous violations of the housing maintenance code in the Chelsea and the apartments, unquote. In order to reach this finding, the court engrafted onto Administrative Code section 27-2115 H2I a pleading requirement beyond what is set forth in the text of the statute. All the statute states is that the allegation, quote, be based, at least in part, on one or more violations of record.
So it's your position that the harassment claims are based on what they say, are based on the violations for harassment. Is that right?
That is
and that
correct.
They should be sufficient from that perspective.
That is correct. That is correct.
Is there anything else? Is there a question by you?
I'm sorry.
I was asking you if you had a question.
I do. I want to ask you, wouldn't it make sense to plead the the statutory violation? Because what if you don't, and then in discovery, the first thing you're asked is what statutory violation you have, and you can't really plead anything, and then the defendant is stuck with having to do the whole case of discovery because they know they're only entitled to make one summary judgment motion. So they've got to go through all the discovery, even though you never really had a good statutory violation. So doesn't it make sense to plead the statutory violation?
Well, if I can answer that kind of tangentially, right? This respondents did not move pursuant to 3211A1, saying that there were no violations. They get the violations, right? It's not a surprise to them that there are violations. And while it may be inartistically pleaded, what that allegation in paragraph 29, plus the very detailed allegations in paragraph 13, I mean, they were so detailed that the court described them as a laundry list, certainly puts them on notice of the substance of the claims, including that there are one or more violations of record. I'm sorry about the tangent, but I think I responded to your question, Judge.
Justice Higgett, did you have a question? I thought I saw your light on.
No, thank you, Judge. Justice Pula covered what I was going to ask.
Okay, any other questions? Okay. Anything else, Mr. Heaney?
If I can move on to two other points then. One, as to the argument that the Supreme Court is not a court of competent jurisdiction to hear this matter, that has already been addressed in Job versus these respondents. And on both the appeal and the motion for re-argument, the claim was denied. This court found that the Supreme Court is a court of competent jurisdiction to hear these claims, and it's clear in the statute.
That's right. You should move on to your next. You said you had two more, and your time is running out. So move on to your second.
And that would be with regard to punitive damages. If one reads the complaint here, there is clearly abhorrent conduct, including, quote, vandalizing and, quote, destroying the apartments. That's also set forth in paragraph 13. That plus simultaneous infliction of the many deleterious conditions listed in paragraph 13 make it so that there's nothing, quote unquote, garden variety about this. This is a deliberate and wanton disregard of appellant's interests. And I would ask that the matter that these causes of action be reinstated, including the claims for punitive damages. Thank you.
Thank you.
Good afternoon.
Yes.
Jennifer Racine for respondents, Chelsea Hotel Owner LLC, SIR Chelsea, and Ira Drucker. As the court's well aware, this is an appeal arising from a dispute between the appellants and the
yes, we are aware of the facts. You should get to the legal issue.
Okay, so we have, and I would like to address first one issue that was raised by opposing counsel, which is that it is true that we have agreed that certain of these claims should be reinstated. That is an offer that we made to the other side, and we had said that they could have been reinstated months ago. That was something that was rejected by the other side. We also will not make any comment whatsoever on intentional infliction of emotional distress or the issue of where these claims can be brought. We are preserving them only for appeal after summary judgment and or trial. The only remaining issue that we would like to raise with the court.
I have a question. This is Justice Kennedy. So I know that you do not challenge reinstating the nuisance and the intentional infliction of emotional distress claims, but you are still challenging the demand for punitive damages. So my question is, in light of Job, where this court indicated that such a demand may be appropriate if the acts are shown to be malicious or intentional, how do you address the Job decision?
This case is factually distinguishable, which we pointed out in the papers, and we would rest on those papers. The only distinction I would draw the court to, if you are in fact interested, is the fact that here, unlike with Job and Post, who were folks who were more dependent on their primary residence. In this case, these particular appellants have a different home. They do not live in the unit. They've acknowledged in the pleading they do not live in the unit, and they have not lived in the unit while the facts at issue transpired. So it's hard to understand or perceive the way in which they could have suffered in any way that is analogous to the potential suffering of Job and Post, who had no other place to go and lived in the purported conditions as alleged in the complaint.
Well, counsel, excuse me, isn't it hard to gauge suffering on a 3211 motion? We have allegations, and now they either need to be developed in discovery or they fail for want of a sufficient pleading as a matter of law.
If they do not live there, which is something they have acknowledged in their papers, then we do not think that this is a matter that needs to be factually developed. If they live in Cornwall, Connecticut, which is where they live, then it is impossible that these same conditions could develop to the point where a punitive damage award.
Counsel, this is Judge Scarpula. Don't they actually allege that they had to move out of the apartment because of those conditions? Isn't that what they allege in the complaint? And so at some point, the allegation is they did suffer those conditions and then they moved out. Correct?
We've said we are putting this in on submission if that is your honor's view and you believe this.
No, it's not my view. I'm asking you, isn't that what the complaint alleges? I don't have a view at all.
Well, I think the complaint is very careful about not alleging when any of these incidences occurred or acknowledging when they moved out. So
well, then it sounds like you're leaving it open then that there is an issue of fact.
I don't believe there is an issue of fact.
Okay. Did you have another issue that you
Yes, and this is the primary issue and the only issue.
The harassment issue?
And it is only as it relates to the record violation. And this is an important issue. It is based on a reading of the statute. My opposing counsel is not being transparent about what the statute says or how it works. The statute is very clear. 27-2115H is what sets forth what a tenant must do and what a tenant must allege in order to maintain a claim of harassment under the statute. And it is very clear that where one or more allegations of harassment pursuant to this provision concern the physical condition of the dwelling, which all of the allegations do here, such allegation must be based, at least in part, on one or more violations of record issued by the department or another agency. There is no other provision in 27-2115, which concerns civil penalties related to harassment, that permits a tenant to bring a claim. The provision of 27-2115 that my opposing counsel points to save his complaint is one where a court can find, a court of competent jurisdiction may find that a Class C violation exists without having pled one, but that does not apply to tenants. That applies to someone else who is bringing a claim in a court of competent jurisdiction. And I spent some time thinking about this because it is our obligation to read this statute in a way that makes sense and doesn't render any part of it meaningless. And if you accept that Mr. Heaney, Mr. Bahar, and their clients may prove later a violation of record without having referenced it in their complaint, and this is a distinguishing factor between Job and this case. In Job, there was a record violation alleged. Here, there is no record violation alleged. There is simply a statement that there are hazardous violations. There's no specific record violation alleged, which is what's required. So if we read that out of the statute, then the statute H makes no sense, but you can read M and H together in a way that does make sense. And the way that we do that is by seeing that there are other parties other than a tenant that could bring a claim in a court of competent jurisdiction where it would make sense for a court to be able to find without an allegation in the pleadings that there is a Class C violation. In reading The Real Deal today, I see one. So for example, Attorney General James started an investigation about a landlord that she felt was abusive. And in the course of that investigation, she eventually—
Your time is up, counsel, so wrap it up, please.
I was just going to say that is an example of where a party other than a tenant would need Section M. So you can read this provision in a way that works together. And if you do that, it is clear that it is required that a tenant plead a record violation, which unfortunately has not happened here.
Are there any questions from the bench? Thank you. Thank you, counsel. I think we go back to Mr. Heaney.
Yes, just briefly. There is nothing that would be read out of this statute in reinstating the first cause of action for harassment. That's because the statute provides that the allegations shall be based, at least in part, on one or more violations of record. The allegations in the complaint are sufficient to do that on a 3211 motion.
Well, so then, counsel, I'm going to ask you, what violation of record have you pled?
We have
I
pled.
mean, that's a term of art. It's not just a general thing.
Well, Judge, we have pled that there has been a repeated failure to correct hazardous or immediately hazardous violations of the housing maintenance code at paragraph 29 in the brief, in conjunction with the conditions we listed earlier. That pleading has to be liberally construed. The reasonable interpretation of that paragraph with paragraph 13 is that there are violations of record. It's not that there's nothing here. There's far more than nothing here, and there's enough on a 3211 motion to sustain the claim.
And sir, so at what point then is the ball in your court to disclose the specific violation or violations that are serving as the predicate for the allegation of harassment?
Either a demand for bill of particulars, a request for a more detailed statement, or discovery.
Thank you. Any further questions from the bench? Thank you. Thank you both.
Thank you, Your Honors.
Cesar Ramirez versus Natalie Handsome.
Good afternoon. May it please the court, Alexander Shapiro for plaintiff appellant Cesar Ramirez. This is a label.
Sorry.
I'm sorry. Can everybody hear me and see me well?
Yes, yes. I wanted you to know that you could begin.
Thank you. Thank you, Your Honor. This is a case involving a construction site accident. The subject.
Yes, we understand. This is a single family home. So why doesn't the homeowner's exception apply here?
Well, there are a number of reasons. Firstly, the owner of the house, who was the original owner, has not been living there since 2012.
I don't think that's an exception. I don't think that changes the exception.
The reason, Your Honor, is that there are a number of things. Firstly, the defendant, Michael Hansen, based on his LinkedIn page, he's engaged in a professional home renovation business.
Let me be clearer. He has a home renovation business. This home, however, was purchased by his father in 1958 or whatever the year was, and then lived in by his stepmother, who hasn't lived there for a while. There's no evidence in the record that it's been rented, no evidence that it's been anything other than being prepared to be sold. It's not in the business's name, it's in his name, his brother's name, the stepmother's name. So what evidence is there that this is part of the business, or anything that shows that he's preparing to sell it for the business or anything else?
Well, firstly, Your Honor, the juncture to which this motion was made was right after we agreed and we did a stipulation to vacate the default judgment. We didn't get a chance to do any discovery. We don't have a copy of the contract for this house. We don't know, maybe he did do the contract in the name of his home renovation business. We don't know the timing when the contract was entered into, because the construction work at this property began even before Michael Hansen became an owner of the property, which raises the question whether he was an agent of the owner at the time when he retained the contractors. We don't know whether he retained the contractors on behalf of his mother at the time when he wasn't in the deed. We do not know if the mother retained the contractor. We don't know if he himself was acting as a general contractor. What we know is that this wasn't a situation where there were some minor repairs done to the house. This was a gut renovation. The walls were demolished, the floors were demolished, everything was replaced.
So, counsel, this is Judge Scarpula, and so your client testified that he was doing renovations for a year, correct? And that's what he testified. I mean, I read his deposition testimony. That's what he said. And the home renovation thing that you're trying to hang your hat on started 2 months prior to his accident, the plaintiff's accident, correct? So clearly that wasn't, I mean, that doesn't connect.
Your Honor, well, firstly, the plaintiff never testified. There was an affidavit here. We had no.
Oh, I'm sorry, you're right.
Yeah,
But I think he said I had been working on the house for a year before my accident.
Correct.
And then, so you go on a LinkedIn page and you find that 2 months before the accident, the defendants, one of the defendants starts a home business. And from that, you want us to order discovery?
Well, Your Honor, that's when he posted it and linked it. At that point, he said he already sold the houses as part of the home renovation business, and he already renovated them, and it's not going to be renovated in 2 months. What's clear here, Your Honor, is that the renovation work, which is not just renovation, it's a got renovation. It didn't relate
to a single family house, right?
But
It's a
it
single
didn't
family
relate.
house.
The house was listed for sale since 2016, since 2 years before the accident.
But it wasn't sold, and it wasn't sold by his business. I mean, and there's no connection to his business.
But we don't know. We don't have the contract even. We don't know if the contract was signed under the name of his business. They didn't provide the contract as part of the discovery. No, not discovery, as part of the motion. We got completely nothing to go on because as soon as we agreed to vacate the default, this motion ensued. And what ends up happening is we have a grave injury here. We have a guy with catastrophic injuries. There are potential third-party claims that could be brought. There may be contractual indemnity, but none of that is being pursued. We have a guy with a brain injury, back fractures, hip fractures, wrist fractures, and we have clear labor law violations. And with this,
that may be so, but he didn't seem to have any control over the means or the method of the work. So those sections 200 and of the labor law wouldn't apply. And then you have this exception that with regard to the homeowner's exception, I understand that there are serious injuries, but this still has to provide a basis to not apply the exception. Let's hear from opposing counsel because you've already had your 5 minutes.
Can I just make one quick point?
Okay.
Would the situation be any different, Your Honors, if the house was completely demolished and they built a new structure, even if it's a one family, but they did so for the purpose of selling it? Because this is in scope and scale, the type of renovations that were involved here.
If it was a private owner, it's a private owner. If it's not a business, it's not a business. Let's hear from opposing counsel.
Good afternoon, Your Honors. This is Tristan Montague, attorney for Wade Clark Mulcahy, representing Natalie Hanson, Michael J. Hanson, the defendant respondents. As you all have identified, the facts in this case here are very clear. We're dealing with a subject premises. That's a one-family residential dwelling. It's remained that way prior to this accident, after this accident. Michael Hanson did own the premises and contracted for work to be done on the premises, and Michael Hanson did not direct or control the work. The trial court properly found this and ruled this. Now we have the analysis really should have ended there. However, plaintiff now is attempting to create this issue of fact regarding the residential nature of the dwelling, also regarding the intent. However, none of these are really dispositive in this case. Plaintiff's counsel keeps bringing back this contract, and I just want to clear up that point really quickly. Based on plaintiff's own affirmations that the respondent, Michael Hanson, from his LinkedIn profile indicated that he started his business in April of 2018, this in and of itself would mean that Michael Hanson, to the extent this contract was even presented, it wouldn't be under the name of his business as it hadn't been started at that point. The renovation project started, as mentioned, almost over a year prior to this, in like June of 2017, from what I believe. Plaintiff cites some cases regarding like the subjective intent of the homeowner, but all of the cases that plaintiff cites to are distinguishable from the record here. Plaintiff's assertions that the Michael Hanson never lived at the premises at the time. the trial court also ruled, which is true, that, those are not dispositive factors here, because for all intents and purposes, at all times from the very inception of this home being built in 1957, it never lost its original characteristic, its original nature of a residential home. And even Michael Hansom's affidavit, he specifically expresses, he also did live there occasionally from time to time while the renovation projects were being done. So it never did lose that appeal. Again, like I mentioned, this case is distinguished from the cases that plaintiff's counsel cited to regarding the intent at the time of the injury. It's always remained yes.
I don't want you to repeat, but if there's anything, if there's nothing further, any questions from the bench? Was there anything? Why don't you wrap up then?
I don't believe I have anything else. I really honestly.
Thank you very much. Thank you very much.
Thank you.
We're back to you.
Yes. Well, in terms of the case law from the Court of Appeals and from every other appellate division department, just because a property is residential doesn't mean that the homeowner exemption applies, because you could have a commercial purpose with respect to the construction work, renovation work.
But what evidence do you have of that? That's what we are trying to find out. What evidence do you have other than he has a business? The business has no connection to this. Well, the business was created afterwards. That's what.
I think, first of all, there's no evidence that the business was created afterwards, because the business posting.
Okay, what evidence is there that the business owns this property?
Perfect description matching the LinkedIn with the real estate broker listing profiles. The properties are a perfect match. The one on LinkedIn and the
Counsel, this is Judge Scarpua. I mean, there's a deed to the property, right? Who's the deeds in the name of?
The deed is in the name of both of these individuals.
So how could it be in the name how could it be owned by this new entity if it's in the name of the two individuals, right? Well, that's easy enough to discover.
Well, it could be a sole proprietorship. That's what this entity appears to be. It's a sole proprietorship.
I mean, okay, yes, the 10 million things could be, but that doesn't mean that you get to go on a fishing expedition, right?
Expedition, Your Honors. We should have had at least an opportunity to get the copy of the contract. We should have had an opportunity to do the depositions, and this really leaves the plaintiff without a remedy. And based on the totality of the circumstances, clearly there's evidence of a commercial purpose. And more importantly, Michael Hansom, the respondent, never submitted any affidavit, anything disputing our position that this was a commercial enterprise. This was done as part of this home renovation business. He only said it wasn't rented. That's all.
Thank you. We'll carefully consider both of your positions. Thank you very much.
Thank you.
DeLuca versus Hafen Capital.
Good afternoon, Your Honors. May it please the court. David Mayer for the plaintiff appellant, Joyce DeLuca. This case involves the sale of a business where 85% of the purchase price was being paid pursuant to an earnout, depending on the performance of the business after the sale. So if certain
and the sale was made for the purposes of Ms. DeLuca to have more capital so that she could grow her business. Is that right? I mean, that was one of the reasons.
That is correct, Your Honor. That was the central reason. And it was structured so that Ms. DeLuca got a relatively small upfront payment, and then 85% of the proceeds of the sale were paid to her upon the business hitting certain asset under management.
So the way she was going to make her money here was to hit these milestones, to get the milestone payments once she had
Exactly, Your Honor. And as a result of that, there was an express provision in the transaction documents that says buyer shall not intentionally act in bad faith for the purpose of avoiding any milestone payments. And that was the underlying premise of the breach of contract, the express breach of contract claim that was asserted here. It was pled in the complaint, section 2.02, which contained the
now
covenant.
You had originally proceeded under section 7.03, isn't that right?
Not in the complaint, Your Honor. In the complaint, which was before the trial court on a motion to dismiss the complaint in detail pleaded section 2.02, which is the express covenant not to act in bad faith after the closing during the earn-out period. That was discussed in the complaint, and then the first cause of action expressly referred to section 2.02 and said that the buyer acted in bad faith in order to prevent the earn-out triggers being met here. And the complaint also laid out a number of respects in which that bad faith occurred. One of which, and one of the central provisions of which, was not to draw down on capital, a capital commitment that had been obtained. And although the capital commitment had been obtained as a condition of closing, the purpose of the capital was to use after the closing, during the earn-out period, in order to acquire these loans, warehouse these loans. This was part of growing the business that was required in order to operate the securitization piece of it. So the complaint alleges, right in the complaint, before we even get to the motion, but the complaint was before the motion court on a motion to dismiss. The complaint alleges this express covenant not to act in bad faith. The complaint alleges the failure in bad faith to draw down on the capital. It alleges the failure in bad faith to provide any marketing personnel whatsoever for the business, despite all other divisions had marketing personnel. It alleges the failure to introduce the plaintiff who was running the business to any investors, which again was part of the deal here. So there were a range of bad faith actions that were taken, Your Honors, and alleged very clearly in the complaint in this case that was before the judge on the motion to dismiss. The waiver argument that's been made by the defendants in this case it must fail because the complaint itself lays out the very case that we're arguing right now, which was the violation of the covenant not to act in bad faith. In this court's decision in Bitter versus Renzo, this court implicitly said that if you either, or expressly said, if you either allege and plead.
Counsel, this is Judge Scarpula. You're telling me that you specifically alleged below and argued to the trial court that the failure to allow the plaintiff to draw down on that capital commitment was a breach of the covenant not to act in bad faith?
I'm telling you, Judge Scarpolo,
I want to hear what you have to say, but that's a pretty specific question. I'm not disagreeing that we could look at it. I'm just saying I didn't see you actually allege that specific breach. So if you're saying you did, tell me where.
Your Honor, in the papers, in the brief, in opposition to the motion to dismiss, I do not believe that was alleged. We were not counsel, but I
feel like you're saying to me now, what's the big deal? We pled that, and how come it got dismissed? I don't think that's quite right. We might still look at it, but I don't think you argued that below.
Counsel below did not argue that to the trial judge, Your Honor. Right. I concede that.
Right.
However,
you're saying the facts are in there, and we should construe the complaint liberally, and therefore doesn't matter.
Exactly, Your Honor. Under this court's holding in Bitter versus Renzo, in which the court said essentially, you can, if you neither allege it plainly in the complaint or articulate it in the complaint, nor do you raise it in the briefing in opposition to the motion to dismiss, then it's been waived. In this case, while I concede that counsel below did not argue it expressly in the brief, it was right there on the face of the complaint. If they had submitted no opposition papers, Your Honor, at all, and the judge was simply required to pick up the complaint and say, does this articulate a cause of action? Let's
move on from that. And let me just ask you about why. So the argument, I guess, of the defendants is that that obligation to allow her to draw down comes from a schedule which conflicts with the agreement itself and therefore can't form the basis of that breach of contract cause of action. What do you say to that?
Two responses, Your Honor. First of all, the body of the purchase agreement itself says that the commitment must be obtained on the terms that are substantially similar to a term sheet that then is annexed as Exhibit B. So Exhibit B cannot conflict with the contract when the contract says Exhibit B must be followed substantially. So in Exhibit B, it's undisputed, Your Honor. Exhibit B says either that the capital that's obtained has to be usable either for warehousing the loans as part of the operation of the business or for risk retention purposes. We agree there's no longer a risk retention requirement, but there was always, and there still was very much a need for this capital to acquire, warehouse these loans and grow the business. Secondly, Your Honor, even if that were not the case, the bad faith clause applies to whatever capital this company had obtained. So the capital that was actually obtained, even if it went further than was required to meet the terms of the closing obligation, once you have the capital, you can't not use it in bad faith. That's what that clause says, Your Honor. And the capital that was actually
wrap up because I've already gone over your time.
Yes, Your Honor. If I can. Yeah, I apologize. If I can just briefly address the duty of good faith under the side letter. So if for some reason the express covenant doesn't carry over into the side letter, which was part of a single set of transaction documents that were referenced and cross-referenced and defined as a single set of documents, if it doesn't carry over into the side letter has an implied duty of good faith that arises under English law, which governs the side letter. Now, the trial court actually granted plaintiff the right to replead, to plead English law, which was a requirement of the CPLR that hadn't been met. He granted that after oral argument from a ruling from the bench and then revoked it the next day in a written decision for some reason. Now, that leave to amend should have been given here, Your Honors, because we simply could have pled English law. We cite English law. It implies a duty of good faith. And the only response the other side has made is to say, well, there under the side letter, there is a forum selection clause that requires England and English courts. Now, number one, that's not true, because the forum selection clause in the main purchase agreement says this overrides anything that's inconsistent in the other documents, and therefore the forum selection clause in the purchase agreement must apply to all of the transaction documents by virtue of the clause that says that anything inconsistent is overridden by the purchase agreement.
Well, why is that inconsistent? You could have two different, you could have one that says go to England and one that, and the rest of it goes. There's no inconsistency with that. And in fact, we've often in this court enforced more than one forum selection clause in a number of documents. There's no inconsistency there.
Well,
you may
actually,
be able
you
to
respond to that on rebuttal.
But yeah, I don't see why we shouldn't.
If I could just make one,
I'm
point.
going to let you respond to that on rebuttal because I've given you almost double your time. Thanks.
Yeah, yes, Your Honor.
Let's go to the other side.
Good afternoon, Your Honor. Scott Wilson, DLA Piper for the Hayfin respondents. You've heard counsel advance again here today the argument that the capital commitment described in 7.03F of the purchase agreement was for the purpose of growing Ms. DeLuca's business once it was integrated into the larger Hayfin asset management business. We don't have to guess about what the purpose of this commitment was for. It was expressly described in the contract as being, quote, for the purpose of enabling the company to satisfy the U.S. risk retention requirements. A month after this transaction closed, by operation of law, decision of the DC Federal Court of Appeals, DC Circuit Court of Appeals, those risk retention requirements rolled off and were no longer applicable. In other words, the entirety of plaintiff's claim here boils down to an argument that it was bad faith or in violation of 7.03F for Hayfin not to deploy a capital commitment obtained for purpose X for purposes that are not X for any other purposes. In fact, the complaint itself alleges that Hayfin did make 70 million or so of this capital commitment available to Ms. DeLuca and her business unit after they were acquired. But there was no breach of contract here because the condition precedent set forth in 7.03F didn't survive closing, as condition precedents don't. These are sophisticated parties represented by deal counsel in this 65-page agreement. It's an integrated agreement with an integration clause at 10.06. Had Ms. DeLuca wanted to bargain for specific operational controls of the larger Hafen business once her company was integrated into it, she could have asked for and attempted to negotiate those things. There's no evidence of that. Instead, we have an integrated agreement with just this commitment in it for a purpose that was superseded through no act of either of the parties. The 2.0
she's moved, yeah, 2.02. Why don't you address that?
The 2.02 argument that plaintiff advances for the first time on appeal
Which is
simply,
okay. Which is okay. All right.
Indeed, and our
right,
opposition our opposition
Let's not
to it
waste
is,
time on that because 6 minutes goes very quickly, as we found with opposing counsel. Go ahead.
Yes, Your Honor. It's merely a restatement of a redundant of the 7.03 argument. And if you look at the reply brief on paragraph 4, counsel writes, Hafen's failure to provide the growth capital is the gravamen of Ms. DeLuca's breach of contract claim. This summarizes the primary factual underpinning of her claim of a breach of section 2.02. In other words, the section 2.02 argument relies on a more general statement in the contract that Hafen should not engage in intentional bad faith to deprive Ms. DeLuca of certain milestone payments. The basis for that argument is that the commitment, which was to be provided for her to help that business unit accomplish certain regulatory compliance with the risk retention requirements. Once that no longer existed, it was bad faith, intentional bad faith, to not deploy it for other purposes, or rather, according to the allegations of the complaint, to deploy it for $70 million worth of other purposes, but that's intentional bad faith not to do it. We submit that strains credulity. And in fact, the more specific provision of the contract at 7.03F, which actually describes what the parties understood the purpose of this commitment to be for, governs over this more general language.
That was one aspect of 703, but doesn't 703 incorporate Exhibit B?
7.03 incorporates Exhibit B, absolutely, Your Honor, but 10.06 of the agreement is not just an integration.
And I think counsel has just talked about how we should have an expansive reading of that.
Right. To the extent that counsel is correct in arguing that there's any inconsistency between the content of Exhibit B and the language of 7.03F, Section 10.06 is not just an integration clause. It specifically provides that in the event of any inconsistency, the text of the main agreement, the body text of the purchase agreement, governs in the event of any inconsistency.
But counsel, this is Judge Scarpullo. Why is it inconsistent? What's inconsistent with saying I'm gonna get this money for this purpose, and then in a schedule also saying, and by the way, I'm gonna commit that money because that's the whole purpose of this, of the way that this agreement is structured. I'm going to commit that money, which I agreed to get to satisfy. There's nothing, at least there's nothing straight up inconsistent. It may be at the end of the day that that's not what the parties intended, but it's not straight up inconsistent to say both of those things.
We would argue that it's inconsistent to say that the commitment in 7.03F was obtained. That was a condition precedent to closing, which the plaintiff could have waived. Here it was not waived. Hafen obtained the commitment, the capital commitment. Plaintiff concedes that on appeal that they did obtain it, and they obtained it for a stated purpose.
No, but why is there not consistent to also say, yes, that's why we're getting it, but since we have it, in Schedule B, we agree that we're going to give it to you because that was the whole purpose. Your whole purpose of entering into this sale was to give you that bigger amount of capital to work with. So I don't see, I mean, at the end of the day, that might not be correct, but on a pre-answer motion to dismiss or under 3211A7, why doesn't that survive?
What plaintiff is attempting to do is to take that language in the exhibit and infer from it an unstated.
Well, doesn't the exhibit itself say that it incorporates?
The 7.03F certainly says.
Yes, doesn't it say, and I incorporate Exhibit B? So it's not like plaintiff is shoveling it in where there's no basis to do so.
7.03F, yes, Your Honor, incorporates the term Exhibit B as describing the terms of the commitment that should be obtained per 7.03F, quote, for the purpose of enabling the company to satisfy the U.S. risk retention requirements. It's our
Doesn't
contention.
only say that. I'm sorry. I'm going to end. I don't want to run.
You can continue, counsel. You're over time, but I let counsel, Mr. Mayor, go over time. I'll let you go a little bit if you have more to say.
Thank you, Your Honor. Let me address briefly the motion to replead the claim for breach of the implied covenant under the side letter. We oppose that on the grounds that it would be futile to grant leave to replead the cause of action for breach of the implied covenant under English law, because were plaintiff to do so, it would be subject to dismissal because of the exclusive jurisdiction clause in the side letter. Below, they only asserted a cause of action for the New York implied covenant, but were they allowed to replead the implied covenant under English law, we would move to dismiss successfully, I believe, for, among other reasons, the lack of jurisdiction. And I'll leave it there, Your Honors.
Okay, thank you. Counsel?
Yes, thank you, Your Honor. If I can pick up on that last point and go back to Judge Scarpulla's question that she asked me earlier, there actually is a direct inconsistency between these choice of forum clauses, because the choice of forum clause in the purchase agreement says it applies to all of the transaction documents. And I'm reading, it says, any legal suit, action, or proceeding arising out of or based upon this agreement, the purchase agreement that is, the other transaction documents, which expressly are defined to include the side letter, must be or are subject to the courts of the state of New York, and each party irrevocably submits to the exclusive jurisdiction of such courts. So the purchase agreement says that for this purchase agreement and for all of the related transaction documents, which is a defined term that includes the side letter, there is exclusive jurisdiction in New York courts. The side letter, inexplicably, I can't tell you why, Your Honors, the side letter has its own choice of forum clause that purports to require litigation in English courts, but conflicts directly with the main body of the purchase agreement, which, as both sides agree, if there's one thing we both agree on, Your Honors, it is that there's a clause in the purchase agreement that says if there's a conflict between this agreement and other documents, this agreement, that is the purchase agreement, controls. The statements in the body of this agreement, this purchase agreement, will control. So there is no defense based on that forum selection clause, and therefore it would not be futile whatsoever to allow us to replead under English law. Thank you, Your Honors. I'll rest there.
Okay, thank you both. We'll consider your arguments. Cirrus versus Katz.
For the respondent, Gerard McCrate.
Adam Pesca for the law firm of Richard J. Katz.
Why don't you begin?
Yes, Your Honor. Straight to the point, straight to the argument is their motion for summary judgment didn't establish a prima facie entitlement to summary judgment, particularly the affidavit from the debt purchaser. An officer from the debt purchaser submitted an affidavit alleging a missed payment in October of 2016. Ironically, in 2016, in October of 2016, my client made a payment of $14,000, in excess of $14,000, and had been continuously making a flow of payments after the cancellation of the credit line, which is an issue. It's a credit line for the sum of $750,000 that my client dutifully serviced for since 2007. Our position is they never established a prima facie entitlement to establish a default. And even if a prima facie entitlement was established, the affidavit from Richard Katz saying that he was working with Citibank very closely and monitoring and making sure that monthly payments were paid every month, the minimum payment. So for them to default a year later from the Platzer-Swergold letter of default was just totally ridiculous.
So this is John Higgin. I'm curious, going back to the prima facie argument, what is, in your view, the deficiency or deficiencies in their prima facie showing?
There are two, Judge. One, that the affidavit is just bare bones, just summarily states that there was a missed payment in October of 2016. And secondly, they point to no document from Citibank, any type of supporting document to say that, hey, there's a default, there's a statement, this is amount due, you didn't pay this. There's absolutely nothing. All there is the original agreement from 2007, an amended agreement, and a payment, a history of payments. If anything, shows directly there was a payment of $14,000 in that particular month, and over $110,000 thereafter. So, I mean, this is a good. I mean, it gets to a point where, you know, the firm has been dutifully acting throughout 13 years, and to not get a default letter. And obviously he was relying upon the vice president of Citibank to tell him what needed to be paid. And he articulated in his affidavit, he steadfastly maintained that in his deposition, saying, I signed whatever they wanted. I did whatever they asked me to do. I made whatever payments that needed to be paid, and they defaulted me. And
Sir,
now there's a judgment
sort of
against a reputable firm for over $600,000. And it lacks, it reeks of bad faith. And if you have any questions, I would just submit on the briefs.
Sir, putting aside any sort of, custom or some sort of a courtesy that could have been extended, was a demand a condition or a precursor to them declaring a default and moving forward?
No, Judge, there was not. That was, there's nothing in the record. In fact, that's something that my client highlighted in his affidavit, Richard Katz. There was never a demand. There was never, if there was a missed payment, he says that in his affidavit. If there was a missed payment, I would have rectified it. He was working with a representative by the name of Terry Barber very closely. And I mean, this is just not, it completely, totally reeks of bad faith that every contractor, every person, a party is entitled to. And here we're not talking about, a $10,000 loan. We're not talking about we're talking about a loan for, over, $700,000. There has to be some, comedy, some reciprocity for the thing. He had been servicing this credit line. This is not somebody who's trying to obviously skirt his obligations. He's on top of it every month. There's an amount that it looks like it averages every month. There's at least $7,000 being paid. It's his affidavit. He says that he made the minimum payment that there was required. There was some communications they were going to try to, he wanted a longer payout. He was trying to modify the agreement. Under the terms of the agreement, the revolving credit line, they can cancel at their option, at their sole discretion, but he's still entitled to the 48-month payout. And he just wasn't given that.
Let me just make it clear. Are you saying that he paid everything that he was supposed to pay under that equal? I mean, it's not that hard. It's 48 payments. You split the amount. He knows what the interest rate is. No one has to tell him. It's in the agreement. Are you saying he made every one of those payments?
No,
and if
Judge.
You look at the business records, it would show that he made those payments?
No, Judge.
So he didn't make the payments. He didn't make the payments that he was required to make. That's what I'm not clear. Are you saying that he did or didn't?
He made, under the agreement, he was required to make 48-month payments, 48 out of 48 months. I will also note that the agreement.
I just want to know, Are you saying that up until when they defaulted him, that all their business records are wrong and he actually did make all those payments?
No, he didn't. That's correct.
Okay. You're saying that he didn't make the payments, but he was in negotiations with somebody from Citibank and that they should have extended him the courtesy by sending him notice.
That's exactly correct.
Default letter, and you feel you didn't get it. Okay, let's hear from opposing counsel.
Judge Scarpella and I think you hit the nail on the head. The record here is very clear. There's a transaction history in the record.
Well, it's not always simply you missed a payment. I mean, there are procedures that have to be in order. Why don't you tell us how you, Citibank, followed that? And talk about the fact that I think in what he's saying is the fact that he was in negotiations with Citibank, and in the meantime, they're sending him, this notice of default. It's a little shameful almost, but it sounds like Citibank, it was just too good to be true, this deal, and he couldn't meet it. It was time to cut him off.
Well, I would respectfully disagree, Judge. I think when there's over $500,000 that's been outstanding for a number of years. And regarding the terms of the note that issued, this relationship ready credit agreement, it's an auto default. The default is very simply defined as the failure to make a payment when due. There is no right to a notice to cure. There is no right to a notice of default. If the defendant, who is an attorney, wanted those terms in the agreement, the time to do so was before signing the agreement, not when its enforcement is sought as a defense. The note is very plainly stated in that regard. There was a period of time after
you're right. He was having difficulty with the payments. He was trying to negotiate with Citibank. I think that's what he's saying. He was he was well aware of what he was getting into, and then he got over his head and he couldn't make the payments. So he was negotiating with Citibank.
Yes, he was. Now, the note is also clear that it takes in a writing to amend the note. It can't just be amended on negotiations or requests for a modification. And the inability to make payments wasn't necessarily one time. Once the loan was converted to the 48-month repayment period, the payments varied from month to month. Sometimes they're met, many times they're not. Some payments are reversed. So while Mr. Katz is talking to Citibank, there's nothing in the note that says Citibank is going to be bound by that. And Mr. Katz is an attorney. He understands what an agreement says, what it means when an agreement says you can only amend this note by a writing. The fact that he's talking to Citibank about the modification, he understands that the payments had not been made. And the transaction history that I'm talking about was affirmed by Mr. Katz as true and correct. The banking records submitted by Mr. Katz, you can match the payments up to the transaction history. There was a year after the line was closed requiring payments where payments just weren't made.
What was the purpose of Citibank talking to him? What was the purpose of them negotiating with him?
So this is a relationship credit agreement. He had bank accounts with Citibank. The payments were automatically withdrawn from his business account. So you could always talk to Citibank. You could always talk to your banker. It doesn't necessarily mean that they're bound by any of those discussions. And no evidence has been submitted.
They're not at all bound. It almost seems like he's being strung along when he's being told on the one hand, he's talking and talking and talking. On the other hand, it doesn't, Well, in any case, do you have any other points to make? Are there any other questions from the bench? Okay.
No, I'll rest on the brief then, Judge.
Thank you. We're back to you, Mr. Pesca.
Very quickly, Judge, and I'll just make the point about the arguments now that he's missed payments and several payments. In fact, the only argument they make in the affidavit is that he missed the October payment. So thereby, I mean, that's their prima facie argument for the default, is if you look at the record, page 241, their only statement on the default is that he failed to make an October 2016 payment. But in fact, that was made. The record shows he made over $14,000 payment that month. That's my final point.
Thank you. Thank you both.
Thank you, Judge. Okay.
Thank you, Your Honors.
Family Health Management versus Rohan Developments.
As I'm trying to unmute. Michael, if it please the court, Michael Graff for the appellant, landlord Rohan. This is a case where there is no discovery, there was outstanding discovery, but had not been answered. They just made the motion to dismiss and then a motion for summary judgment following it. So the question is, the first question is, was there a lease that was signed and delivered? I say that that's a question of fact, tribal issue of fact. Lease we claim was signed and was delivered. As a matter of fact, we have it in the record where you could see the signed lease.
Counsel, there's the lease that you're talking about that was signed. Was that signed before or after the tenants decided not to take the property?
Signed before. It was signed by the tenant in December, and in January of the following year, they sent a notice saying Mr. Kuttner's client doesn't want to go forward with the deal and wants the money back. But that lease was signed before, and particularly the section of the collateral.
So, counsel, can I ask you? This is Judge Scarpula. Is your argument that Exhibit D, which the tenant clearly signed and says they hereby ratify and confirm the terms and provisions of the lease, and under that document, which they sent the $96,000, that document is sufficient to show that the tenant signed the lease as the party to be charged?
Well, he signed it. He signed that clause, and then he signed 2 guarantees as well. And he also sent an email or a text saying that he signed it. And
right. And he sent, at that time, he sent the time that those documents were signed, not all of them were signed, but some of them were signed, correct?
No, it was all signed.
Is that when he sent something? Is that when he sent another email saying, oh, I made a mistake, that wasn't supposed to be signed? Disregard that?
That was almost a month later when counsel sent a notice saying we withdraw, we don't want to go forward. My client does not want to go forward with the transaction. Please send back the money. He doesn't say which of his clients is that. We know that one of his clients, the guarantor, that didn't want to go forward with it, but everyone else.
No. I think your client signed. I think with regard to Exhibit D, your client signed it, and then right after that, I think said disregard that signature.
No, that's not correct. We didn't even have that yet. The documents which were signed by the tenant were signed before, and we didn't receive that document until a month later, a month after the.
Isn't Mr. Kuttner your client?
No, my client is the landlord. Mr. Kuttner's client is the tenant.
Yes, I'm sorry, Mr. Mehta and Graf.
Mayor is no longer on this case. He never was. He was a former associate of mine 20 years ago.
So it's just Graf then?
Graf, yes. Well, there's 3 Grafs, but I'm the oldest. But in any case, so there is that question. And to me, that is an issue of fact as to whether the contract was signed, the lease was signed. It was signed 3 places by the same principal of the tenant, and it was also a text signed by the same principal saying we signed the agreement. And I just remember the decision in Roosevelt against Kendall, Mr. Capullo was concurred on that, where today we accept a lot of things that were signed by electronic.
I'm sorry. Okay, Mr. Graf, I have to just clarify. What is the date you are talking about where this document was signed?
Document was signed in December of 2018. You could see the notarization of the signatures on the statement, on the guarantees by signed by Dr. Fieldman and notarized in December. So I'm saying that was when it must have been signed. Although he said he signed it also in December 22nd or 21st, he sent an email or text message to my client saying, I signed it, we signed it.
So counsel, this is Judge Scarpula. Is it your position? I think because the court below said there was no delivery, but your position is that by sending that email, that was sufficient enough to show delivery, correct?
No, the delivery didn't
No?
later. Now, what I'm saying, actually, the gravamen of my case was that this clause 25 4C waived that requirement for signing delivery. What happened here was in early on and in December, we were told it was signed, and in January he sent us a check, and the whole point of the check was so that we could go ahead and do the renovations of the soon-to-be medical office. And so we say, and actually the court below didn't even reach this point about signing and delivery because the court focused on 25.4C, which said that it had to be done like that, and it wasn't delivered until February. So I say, and the gravamen of my case is that there was an oral agreement which modified this lease and provided and waived the requirement because the oral agreement says, go ahead and do it. Judge said, well, we jumped, the landlord jumped the gun gratuitously. That's not the case. It wasn't a gratuitously. It was a mutual agreement by both sides saying, I will pay you the $96,000 and to my client, and my client says, okay, I will do the renovation, so that on the commencement date of this lease, which would be February 1st, you can move in. We're not going to start renovation of and building out the.
But the time that all of this was happening, was there one document that had both names on it, both the landlord and the tenants? That both the landlord and the tenants had signed. Was there one document, the original lease?
No, the only names on the lease at the time was the tenants. They didn't send it for the counterpart to us until February.
And wasn't there a provision that said that section 225.4C that you mentioned that said the lease had to be signed by both parties?
Right. However, I'm saying to you that my idol Cardozo said people who make an agreement can also make another agreement to change that. And that's what we say happened in this case. We say that.
I understand. Let's hear from opposing counsel.
There's a lot more. All right.
Well, I went over the time, so let's hear.
May it please the court, Kenneth L. Kuttner on behalf of the respondent. Your Honors, let me jump right to the most important points. As the court recognizes, 24.5.4C of the lease expressly provides that the lease shall not be binding or benefit landlord or tenant unless and until it is signed by both landlord and tenant. The tenant, in this case, 577 161 Street Corporation, did not sign the lease as tenant. By the time notice was given, the landlord, prospective landlord, well knew that tenant was not going forward. This was in late January of 2019. It wasn't until a month later that counsel for appellant decided to send a lease with his client signing it. In other words, when we gave notice, nobody had signed it. The landlord didn't sign it, nor the tenant, okay? But a month after the fact, counsel decides to send, after notice had been given, counsel decides to say, oh, we have a lease, the client signed it. Now, this notion about partial performance and waiver and estoppel is based on the fact that the landlord decided, even before the lease was executed, and the record is clear, to go ahead and purportedly start renovating the premises so it would be suitable for the tenant. Okay, but as the court below recognized, the landlord did that on its own volition. Okay.
Well, counsel, this is Judge Scarpula. How do you explain those texts that you sent? The lease is signed. Here's the money. Let's go. Let's do it. You don't send $96,000. I mean, doesn't that raise at least an issue of fact?
It doesn't, Your Honor, because of the provision in the lease, which I've cited 25.
Yes, I agree. But haven't we moved away from that? Haven't we, as particularly in the First Department, said that there are a number of documents taken together could satisfy that requirement that are not specifically on the document itself?
But there are no issues of fact because they did not understand that we were going forward with the lease. They understood that we weren't going forward with the lease. Moreover, in the documents in the record that counsel has submitted to substantiate the argument that there was that the landlord paid money to bring in a company to do the work, there's no proof of any payments. All counsel has done is included a copy of an estimate. Now, why would someone provide an estimate from months before when he even furnished a copy of the prospective lease? This is not an issue of fact, okay? And people are allowed to change their mind. In commercial situations, it is not unusual for a person or a company to have a last-minute change of heart. So I think—
Sir, this is Judge Hagan. I just want to make sure I understand a few things. First, do I understand you correctly that there was never a lease that was signed and delivered by both the landlord and the tenant?
That's correct, Your Honor.
Okay. And you want us to give effect to section 25.4C as in Charlie, is that correct?
That's correct, Your Honor.
So you want us to give effect to a provision of a lease that was never signed by both parties?
Well, because otherwise, I understand the argument, Your Honor, but otherwise it would render the provision itself, which the court below relied on in both of its decisions, it would render the provision meaningless. Because, and it's not an uncommon provision as is set forth in the various cases that I've cited, okay? So this is not unusual, but intellectually, I looked at it the same way you did, Your Honor, at the beginning, but otherwise it would be meaningless and it would be a Wild West situation in terms of when someone signs a lease or does it. And if I could just make—
And the cases you cite to are mainly landlord-tenant cases, are they not?
No, not exclusively, Your Honor, not exclusively. And in fact, what I've done is I've addressed each and every one of the cases cited by Mr. Graff, and I've also addressed, the case law that he claims the court below erred in its analysis. And it's clear that every one of those cases that the court below cited substantiates plaintiff's claim. There are no issues of fact. And I just want to address one other point. On the conversion issue, counsel has brought up the fact that there was no conversion, but when you take someone's money when you shouldn't have taken, and I'm saying it in its most elementary form, that's conversion. In fact,
actually, counsel, this is Judge Scarpula. Isn't that unjust enrichment and not conversion? Basically, you can't convert money that goes into a general fund, right?
But, okay, let me address that briefly, Judge.
Okay, good.
So first, the court below said it was not going to get to the unjust enrichment issue because they had decided the unjust enrichment cause of action because they decided in favor on conversion. However, it's our position that they had no right to put this money in a fund. So basically, they shouldn't be rewarded because they commingled it. In fact, in page 187 of the record, there's an email from Mr. Graff where he says, this is in response to your client's demand for the return of the security and advance payments held in escrow under the lease, held in escrow under the lease for the subject property. So evidently, at some point, it went from being held in escrow by him to commingled. Okay, and there's nothing in the description of the advance rent or anything else in the lease that even mentions the interrelationship, which counsel spends a great deal of his briefs talking about, between the work and the lease. I submit that if, in fact, there was such a correlation, then the lease, which I didn't draft, that's for sure, should have been drafted in a way that reflected that and protected the landlord if that's what the landlord was disposed of. So
I'm sorry, this is Judge Higgins. I just want to if you could just clarify something for me. What is it your understanding? Where is it that this $96,000 check was deposited into? What type of account?
Okay, Your Honor, I don't know where it was because it wasn't my client's fund. Okay, we gave the money with the understanding that it would be held until such time as the landlord, as both sides signed and delivered the lease. But it never happened because we gave notice before any delivery took place. Because if conversion—
But in that time, you just said something. What was your understanding in that time? It was to be held in escrow?
Yeah, that
or
was—
did you get that belief from what you cited to on page 187 about Mr. Graff's letter to you?
Yes, Judge, it was our understanding that they would not be using the money for any purpose, that it would not be commingled in any way. You cannot make a lease when there is no lease. So there were no obligations that could have ensued from this lease. If this was a business situation, client decided not to go forward. It doesn't matter why the client didn't go forward.
Thank you. Justice Higgins, did that answer? Do you have a further question, a follow-up?
That's fine. Thank you.
Okay. All right. Fine. Counsel, we've gone way over time with you, Mr. Kuttner. Mr. Graff, you had some points you wanted to make. I'll give you time.
Following Judge Scarpola's comment, the money that was sent to us on the 9th of January, and he never told us he wasn't interested until January 29th, 3 days before the effective date where they were supposed to move in. Okay, so, and the money was sent to us as part of a performance. They sent us the money, we did the work. And that was the modification that waived the requirements under 25(4)(c). They weren't going to wait until anything else. They wanted to be in the premises and start the business, not 2 months from now, not 5 months from now. So they sent us the money and we did the work. And
sir, I'm sorry, this is Judge Higgins again, and I realize your time is brief, but if you could just tell me, when your client received that $96,000 check, what did they do with it?
The money was sent by Mr. Kuttner from his IOLA account to a general account. We didn't do it. It was sent directly from Mr. Kuttner's IOLA account to my client's general account. They asked us for a bank routing number, and we gave it to them, and they sent it to our general account, which had tax money, mortgage money, whatever money was required to operate the general business. And again, the first time we heard about an interest in not going forward with the transaction was 3 days before February 1st, the law date for that lease. it was gratuitous for the court below to say, well, we could have started at that time to do 3 months worth of renovation. Meanwhile, they're out on the street and we're not collecting. So
Counsel Judge Rodriguez, I have a question. At the time that you received the $96,000, had you already started? Had the renovations already commenced?
oh yes, this was all part of an understanding because we had a relationship with these people from years before, and so we went ahead with them because they have the next door. They have the next door lot as well. They have one medical office, and they wanted this case involved another medical office on connected to it by a common wall, and so we had this relationship. On conversion, well, I pointed it out. They sent it to Mr. Cutner sent it to a general account. The other thing that's quite important, which I didn't get to talk about, was that although they put Family Medical and 577 as co-plaintiffs, the tenant was 577. That's the one who paid the money. The court below found that the money was paid by 577, but the judgment was in favor of the plaintiffs, plural. It shouldn't be that way. It should be that if there was a judgment, and we feel that it shouldn't be, it should be to 577. And that's because we have another claim against 577 because they're defaulting, but that's another case. But it's important to us that the differential that the court overlooked in making a judgment should be respected. And the court said the money came from 577, but the offered a judgment for the for both plaintiffs, which really wasn't appropriate, and there was no bit of evidence whatsoever as to an involvement of 577 in this payment. They were guarantors. That's it.
Thank you. Thank you both.
Thank you.
Arisi versus Puma.
Yes, Your Honors, Michael Joseph for the appellant. In this case, Mr. Arisi, the appellant, was entitled to judgment as a matter of law because it was undisputed at trial that that Mr. Puma, the respondent, failed to make the payments under the stock purchase agreement, and there was insufficient evidence as a matter of law to establish their affirmative defense of novation by clear and convincing evidence. As this court said in Chavez, insufficient evidence is in the eyes of the law, no evidence. Since it was undisputed that he failed to make the payments, unless he established a novation by clear and convincing evidence, Mr. Arisi was entitled to a judgment. And in this case, that standard was not met. This court has set a firm standard.
Counsel, what about the facts and circumstances that surround this? Can't we look to those to determine whether a novation has occurred?
No, Your Honor, because what this court held in Ventrusi, Goldberg, and Globe Food Services is that it's required explicit contractual language canceling the prior obligation, and it simply isn't here. This underlying contract was a written contract signed, negotiated by attorneys, and you can only imagine the damage that would be done to the commercial world if people could sign written contracts and then just say, well, we agreed to cancel those obligations, and an oral testimony was sufficient. That's why the court in Ventruseli, Goldberg, and Globe Food Services, as well as the second department in Cleat Lumber, have all required unambiguous statements expressed in documents. As this court said in Haynes, if the parties intended to cancel a prior obligation in the contract, they could have and should have done so explicitly in the contract document. And when you look at the one document that the defendants relied on in this case, which is the credit to loan agreement, you can read it from front to back, back to front. There's no language saying that the defendant's contractual obligations under the stock purchase agreement are actually canceled. It just isn't there. And
wasn't there evidence that you're in a different, the case with regard to the attorney Sharp, wasn't there evidence that the plaintiff had submitted an affidavit that where he was asserting that Idaho gave him the note with respect to its business obligations to him?
Yes, Your Honor, but that does not establish
Between
no
Idaho and him?
Judge, Idaho issued a promissory note. That's what
And that
that
it was
refers to.
Idaho, not the defendant, that was obligated to the note, on the note?
No, Your Honor, Idaho was obligated on the note. Mr. Puma was obligated on the stock purchase agreement.
No, I understand. I'm asking you whether your client wrote an affidavit to that effect, asserting that Idaho gave him the note with respect to its business obligations to him, to me, he said, and that after 3 installment payments, Idaho, not defendant, defaulted on its note obligations. Therefore saying that it was Idaho that was obligated on the note.
Idaho was obligated on the note. That there's nothing inconsistent between that position and what we're saying in this case. Puma was obligated on the stock.
Actually, specifically, he said Idaho, not defendant. To be specific, that's what the affidavit said. Idaho, not defendant, which is a little different than if he said just Idaho, which might seem that it was an addition. But he said Idaho, not defendant, which specifically excludes the defendant.
On the note, Judge, the Idaho was the sole obligor on the note. However, under the stock purchase agreement, Mr. Puma signed that. So we can't just merge the two. They're two separate documents. And as this court recognized in Scharf versus Idaho, these are two documents which the stock purchase agreement remains in full force and effect. And that's what this court has said on more than one occasion. In fact, this court in Idaho versus Scharf found that Puma, the defendant, the individual, continues to make payments under the stock purchase agreement, and his personal rights under the stock purchase agreement are not part of this litigation. And in fact, at trial, Mr. Woods, the attorney, conceded that there were two obligations, one under the contract and one under the note. So there was nothing inconsistent in Mr. Arisi's prior affidavit where he says that Idaho had business obligations because Idaho issued a note as security. So there's no inconsistency. Well, there is, however, an inconsistency.
So your client had initially entered into the SPA, right?
My client entered into the SPA with Puma.
Initially entered into the SPA, and then he wanted more security. Right, so that's when the note came about.
Right, the Idaho issued the promissory.
And that's when you're saying that Idaho was added to the.
Idaho became a sole obligor under the promissory note. Idaho obligated itself to make payments, nothing more. It didn't. There's no.
You're saying that it wasn't instead of the defendant. It was in addition to.
Correct. It's a delegation, Judge.
And so was there any kind of consideration or anything for that? Idaho was just added to that?
It was part of a transaction. It secured the payments. It was done as security for the deal to go through. That's enough.
Counsel, the note was executed later. It wasn't part of the initial transaction, right?
It was not. It was.
And the people the person who drafted the note testified that the intention of that later document was to supplant the defendant's obligation under the note. I mean, that was what the testimony was, right?
It was that's what the
document, and there's documentation that backs up that testimony.
There's
also your client's affidavit.
My client's affidavit does not support that in any way, shape, or form.
Maybe you don't think so. I guess the jury did.
But Judge, what the key point, one of the key points is one, there's no it's the defendant's burden to establish novation by clear and convincing evidence. There's no document that actually says that Mr. Puma's contractual obligation was canceled, which is a requirement under this court's law in Ventricelli. Now, if any testimony was also refuted by Mr. Puma's prior affidavit in the note litigation, where he can't say now that I had a novation as a result of a credit to loan agreement in March of 2011 when he submits affidavits in June of 2012 acknowledging he's still responsible for the underlying contract payments. And he sues under the contract personally in October of 2012. As this court's recognized in Warburton, you can't have actions you can't sue under a contract that you're substituted out of.
Your time is up. Let me just ask.
I'm sorry, Judge.
No, I just was going to tell him his time is up, but if you have a question, Justice Scarpullo, you can ask it
I just want to say the CLA specifically recites that they entered into the note pursuant to which Idaho agreed to pay the funds to acquire plaintiff shares of Idaho, right? And
when
you
you look-
sent the default notice to Idaho. All of those are documentary evidence showing the novation. So your claim that there's no documents is just not borne out by the record.
Judge,
I'm just going to ask that you think about the answer to that and answer on rebuttal, because I've given you many more minutes. Opposing counsel?
Good afternoon, Your Honors. May it please the court, Annie Causey for the respondent. Documentary evidence is not a controlling standard for proving novation. Intent prevails. There's no writing that's required. One of the appellant's own cases in his reply brief at page 5, Goldbard versus Empire State, specifically states that sometimes you can infer intent from a document, but other times you have to look to conversation, surrounding circumstances, and extrinsic proof and documents, if any exist. So this idea that there has to be a document signed is not required, and that's been the law for over 100 years in New York, and it hasn't changed. There was legally sufficient evidence on novation. There's a high degree of probability that the respondent's side of the story is exactly what happened. There was a meeting that was testified to unequivocally by all witnesses, including the appellant, where the appellant admitted that he had no right to secure this transaction in order and to get a valuable debtor such as Idaho, and to have Idaho's lease and store contents as security, and to make this this transaction secured. So the only conflict is that we say that the note was given in exchange for releasing the respondent from being individually liable as the debtor, and the appellant says that it's a guarantee. But the jury clearly did not believe the appellant's story and believed the multitude of witnesses, a transactional attorney, the respondent himself, and the appellant's assignee, Jared Sharp, also testified that the note was the payment given to Arisi, who assigned the note to Jared Sharp along with the other loan documents, including the stock purchase agreement, as consideration for the stock in Idaho. And the evidence overwhelmingly supported the jury's verdict. There's no basis for overturning the verdict or giving a new trial. Just a couple of other notes to point out to you. The verdict is not unreconcilable. So the appellant makes an argument about the verdict being unreconcilable because the jury charge, they didn't answer the second question in the interrogatory. But if you look at the jury charge on the breach of contract, let me back up. So the standard is that if the verdict can be reconciled to the evidence in the jury charge, an inconsistency in the jury interrogatory is not fatal to the verdict. And the jury charge on breach of contract stated that you have to find for the defendant if either Idaho was made a counterparty to the stock purchase agreement, or if the appellant accepted Idaho and the note as satisfaction of the respondent's obligations. So they didn't need to go into any other portion of the verdict sheet, including the novation, in order to find that there was no breach of the stock purchase agreement. If your honors have no questions, I will rest. I have some other points, but if you have no questions.
Everybody, thank you. Thank you very much. We're back to you, Mr. Joseph.
Yes, Your Honors, to be clear, what the agreement says, the correct loan, it says.
I think one thing we have to be clear about, in addition, is that this was, as counsel pointed out, this was a jury trial. The jury had the opportunity to take a look at all of these documents, but also had an opportunity to weigh the credibility of these witnesses, which
Judge,
they did.
Judge, you bring up an interesting point, because I think we were prohibited from fully cross-examining the defendant's witnesses because the defendants were allowed, and his witness was allowed to testify to his understanding or his statements of what the documents were. But every time we attempted to use the actual documentary evidence to show what the actual language in the documents were, the judge interrupted me and said the documents speak for themselves, which
well, they were in evidence, weren't they?
They were, which is all the more reason I should have been able to refer to them, Judge.
On them, anybody could have commented on them in summation, or?
Judge, I was given a 12-minute summation, which in a documentary evidence case, to be able to tell me that I can't confront a witness with documents in a documentary case is it is a fundamental deprivation of our right to cross-examination and our right to have a jury see that the language in the documents is different from what the witness is saying they say. And it's virtually at every point I attempted to confront Woods or Puma with the actual documents, their actual language in their affidavits. The court minimized it. He called it arguably inconsistent. They told me to just read it to the jury, or just argue it in evidence. And then he cut short the closing that was so short that we were unable to do so in a meaningful way. So I think we were certainly deprived of our fair ability to present the case, and at a minimum, this case should go back. And we were also deprived. Woods' testimony, his credibility, was the core issue in this case. The judge didn't allow us to go into the fact that he was sitting there billing while he was testifying, that he was a witness while acting as an advocate, and the court also excluded the prior affidavit from his own lawyer, Mr. Rodriguez, in which he acknowledged that Puma continued to be the obligated party on the stock purchase agreement well after the supposed novation, and that the promissory note was mere security for his obligation. These are words out of Mr. Puma's own mouth that the jury should have been aware of, and we should have been allowed to introduce. So I think that if you're going to say a jury, this is more than just a jury making a reconciliation of differing facts. The jury was not allowed to know the facts because we were shut down from fully exploring the documentary evidence, which contradicted the story that the defendant and his attorney put forth, and we were blocked at every point from demonstrating bias and lack of credibility, which was unfair.
We'll take that all under consideration. Any further questions? Thank you. Thank you both.
Thank you.
People versus Michael Hill.
Good afternoon. Sarah Lynn from the Center for Appellate Litigation on behalf of Appellant Michael Hill. May it please the court?
Yes.
Today I'd like to address the Molyneux issue. The footage of Mr. Hill stealing a jacket from the hotel lobby should not have been admitted as Molyneux evidence. It served no non-propensity purpose and unduly prejudiced Mr. Hill.
But didn't it go to intent, which is what the judge said?
That's correct, Your Honor.
That was the reason the judge allowed it, and it was close in time. And I don't know that there was any camera in the woman's room, so it went to show he was in there. He had just taken something, and the main issue there was he also stole things from the locker room. So didn't it go to intent?
That's correct that the trial court admitted it for intent. However, the Court of Appeals had determined in People v. Alvino that where intent is clear from the act itself, the prior bad act evidence must be precluded. And this is the case here.
But was it completely clear where there was no video, no one actually saw him take it there? You know, he wasn't, I can't remember where he was arrested at the time, but weren't there other issues that made this different than that case?
Well, here, Your Honor, Mr. Hill, there's footage of Mr. Hill entering and exiting the women's locker room. The women's locker room is located 5 floors below the main lobby, and it's only really accessible via a stairwell that's rather hidden from the public. Mm-hmm. And so it's not a case where he can accidentally go down 5 flights of stairs and then accidentally walk into a ladies' locker room. The locker room is clearly marked, and so this is a case where intent is very clear from the act itself. There's no question as to intent. And so the prior bad act evidence really acts to prejudice, and it acts as propensity evidence. It suggests that Mr. Hill has a propensity for stealing things.
Didn't the court make clear that that was not the case? Wasn't there a curative instruction that that was not the case, that it couldn't be used for anything other than intent?
It's correct that the judge provided limiting instructions. However, the Court of Appeals has noted that when the prejudice of the evidence is so great, limiting instructions cannot completely cure the harm.
But the case that you rely on, I think, is one where it was a domestic violence case where the video was repeatedly shown, versus here where and it wasn't necessarily close in time. Whereas here it's shown one time, it's very close in time, and there's a curative instruction, and it's narrow, you know, it's tailored, directed toward intent.
Right, Your Honor. Here in this case, it was shown once during the trial on page 35, and then the prosecution actually played it twice back to back during summations on trial page 255 and 258. And so arguably the prosecution exploited this evidence to clearly make a link between this unrelated prior bad act, which was very similar. The similarities in place and time and location severely prejudiced Mr. Hill. And under Molyneux, where prejudice outweighs the probative value, the evidence of prior bad acts should be excluded.
Do you want to move
Lynn,
on
I'm
to the
sorry,
Sandoval? Oh, sorry.
This is Judge Hagan. I'm just curious, what's your view on the harmless error analysis vis-a-vis the Sandoval ruling?
To pivot to the Sandoval ruling, is that your question, sir, Your Honor?
I'm sorry, not the Molyneux, not the Sandoval.
Okay, sure. Here, the error was not harmless. In order for error to be harmless, People v. Crimmins requires that proof of guilt is overwhelming and that there is a significant there is no significant probability that the outcome would have been any different. Here, proof of guilt is not overwhelming. As the prosecution concedes in their response brief, there was no footage inside the locker room, and Tatiana Nichetsky, the main witness who was inside the locker room at the time of the theft, did not see or hear anything. And so it does not meet the first prong of the harmless error analysis. And even if proof of guilt was found to be overwhelming, there could have been a different verdict in this instance. The prejudice here to Mr. Hill is so great. The first piece of footage that the jurors see is of him as a thief. He's shown as stealing something from the hotel lobby, which is not something he is convicted of in this or charged with in this case. And so the jurors get this portrait of Mr. Hill as a thief. And so they reach this impermissible inference that, you know, he did it once, so of course he did it again. And they're basing their verdict off of this super added evidence, which is unrelated and prejudicial.
Do you want to take 30 seconds to talk about Sandoval? Your time is up.
Yes, thank you, Your Honor. In terms of Sandoval, Your Honor, as we mentioned, it was incredibly prejudicial to Mr. Hill to include prior violent felonies that were over 30 years old from the date of his charge. The purpose of Sandoval is to determine credibility, and here there was no need to include those older felonies in order to determine its credibility. We ask that this court reverse the trial court's conviction and order a new trial excluding the evidence. Thank you.
Thank you. Counsel?
Good afternoon, Your Honors. Emily Galt for the People. The uncharged lobby theft was properly admitted as evidence of defendant's intent to steal while inside of the women's locker room. As Your Honors pointed out, there was no camera.
But what about what counsel pointed out, that it goes to propensity? It goes to show that he's consistently behaving as a thief. He stole the coat and now he's down there to steal whatever he can. Well, and the fact that there were no witnesses to what he did precisely. And there, while yes, there were there were videos to show him going in and out, there was nothing to show that he stole anything. Or so, what about that? This went to propensity.
That's why the evidence, the probative value outweighed the prejudice, because there was no camera inside of the locker room. But in any event, this wasn't so.
What was he in the women's locker room for? He's a man who has nothing to do with anybody. He's not related to anybody who had a locker in there. And he's not an employee, and he's in the locker room and he's exiting the locker room. What good business would he have had in there? Why wouldn't that have been enough? Why wasn't it enough?
Well, first of all, he told the arresting officer that he was at the hotel the night prior, but did not do anything wrong. So in a sense, wasn't that something that was investigated? He wasn't there the night prior, was he? As a patron? I'm sorry, he was arrested the following day, and when he was arrested, he was asked why he was being arrested, and the officer said for the night prior, stealing, and he said he was there, but he did not do anything wrong. So he was disputing his intent.
Well, he already did something wrong that was evidenced by the video showing him going in and coming out of the locker room. That was already trespass.
But so for burglary, the people had the burden of proving intent to commit a crime. So this video was.
Of course, but isn't that what the testimony would have been? from all of the people who had their lockers rifled through and everything else? Isn't that what that testimony would have been for? I mean, why was the testimony of why was the video necessary? That's what I'm asking. It sounds like the case was the case with all of the other evidence that was introduced without the video.
Well, the jurors didn't have to necessarily believe that defendant stole anything from the locker room or had the intent to commit a crime. And in any event,
wasn't the evidence that you had almost overwhelming? The fact that there was there were all of these people who said I had XYZ stolen, and I think somebody's lighter, some special lighter that someone had gotten from a relative was in his duffel bag.
Well, Your Honor, I guess
wasn't that all introduced?
Correct. So
what else was necessary? Why wasn't this completely unnecessary and therefore going to propensity rather than anything else?
Well, the video of him taking the jacket from the lobby wasn't so inflammatory or something that the jurors wouldn't be able to put out of their minds. If anything, the theft in the lobby was less severe than the burglary in the locker room. So this wasn't something that the jurors wouldn't be able to overlook and put aside in order to decide whether he committed the charged crime. And the judge, both the prosecutor and the judge, explained to the jury that that evidence was only to be used for intent purposes. So even if this
then why was it necessary to play it twice? Was it played twice during summation?
I believe so, but also it was.
Why was that necessary then?
I'm not sure, Your Honor, but the video, it was labeled as Exhibit 1, and there was also a few other videos. It was the lobby taking plus him entering and exiting the women's locker room, as well as him in the lobby the next day being arrested. So when the people said Exhibit 1 at trial, it's very hard to differentiate which video was actually being played, as we were not there, and the record, the transcript, you cannot figure out exactly which one it was. But in any event, even if it were error, like you said, there was overwhelming evidence of guilt. As defense counsel points out in the brief, it would be a stretch of the imagination to interpret his entry into the locker room as inadvertent or accidental. One cannot accidentally walk into a clearly marked women's locker room located five flights down an unmarked stairwell from the upper lobby. So either way, if this were error, which I submit to you it was not, as it went to his intent and it was not, the probative value outweighed the prejudice. In any event, it was harmless.
What about the Sandoval?
So, yes, Your Honor. So
I think the judge said something about 6 felonies. Usually, was one of those felonies from 30 years ago? Were those felonies beyond 10 years? And what would the relevance have been beyond the 10-year mark?
So, yes, Your Honor. So some of the felonies did date back. The earliest was 1985, which does sound like a very long time ago. But
well, I don't know it either. We both can do the math. It either is or it isn't.
It is a very long time ago. Yeah, so it's very long ago, but at the same time, the defendant was incarcerated for much of that period of time, where it didn't toll for longer than 10 years. So he had 17 prior convictions. The earliest one dated back to 1981. The judge did not allow that. It was just to 1985. And the judge took care to limit it to just 6 felonies instead of including his entire 17 records of a conviction. And also
without the one that was that long, how many would there have been? How many were within the 10-year period?
Well, it tolls because he was in jail for much of the time.
Right. When did he get out of jail is what I'm asking, prior to the crime.
So he was in and out of jail, but his last conviction was in 2012, for second-degree robbery, where he was sentenced to 8 years plus 5 years of post-release supervision. So that was his most recent conviction, but that was 8 years ago. This instant offense occurred in 2019. So he was either on parole, I believe he was on parole, if I'm not mistaken. But in any event, the period told, and the judge took care to shield the defendant, as no inquiry was allowed into the names or the convictions or the facts or any underlying facts of the conviction. So it was just simply one question, whether or not he has been convicted of 6 felonies since 1985, with the most recent being in 2012. So the defendant was shielded. He wasn't prejudiced by that whatsoever. And if your honors have no questions.
Any other questions? Any questions from the bench? Okay, thank you very much.
Thank you.
Ms. Lynn, we're back to you.
Thank you, Your Honor. I'd just like to point out that in summations on page 255, 258, and 265, the prosecution actually spells out what is being shown on the video. And so even though Exhibit 1 does encompass a lot of different video clips, it does in fact, the prosecution did in fact play video of Mr. Hill in the hotel lobby stealing a jacket. I'd just like to also point the court to People v. DiGirolamo, a 2014 First Department case, where this court determined that where the prosecution's evidence left no ambiguity as to defendant's intent, evidence of a similar prior bad act was improperly admitted. In that case, the defendant maced the complainant, stole the ring, and fled. Intent was clear from the act itself. This is the same situation here. The intent of Mr. Hill.
Let me just stop you for a second. I have a question. This is Judge Rodriguez. So the video, I know it was let in for the purpose to show intent, right? But there was also this issue of the people had established dwelling, right? And it went to the intent of the defendant stealing from the lobby, which then goes to the dwelling element. What's your response to that?
Well, Your Honor, the lower court did not admit it for the dwelling. And even if they did, the prejudice to Mr. Hill from this evidence clearly outweighs any probative value. The jury sees this as the first piece of footage that the prosecution enters into evidence, and immediately it paints Mr. Hill as a thief. And so no curative instruction, nothing could erase that prejudice from the jurors' minds.
Any other questions? Okay, thank you. Thank you both.
Thank you.
Molotov versus New York City Department of Buildings.
Yes, Your Honors. May it please the court. Christopher Slowick for appellant. The themes that I really want to make sure that we bring home, and the one that really is the overarching theme for everything, is that the qualifying experience for the license does not itself require a license and does not require supervision in the field by a licensee. That is simply not part of the statutory scheme. And when you start with that, and that's been very well established, then the rest of the rationales that are being used to deny Mr. Polikoff's application for the Ricker's license simply fall away. In particular, the one thing that the respondents never address is petitioners' contention that work outside of the 5 boroughs of New York City counts as qualifying experience. That issue is never engaged with by the respondents. They simply retreat back into this position whereby they try to import or graft this requirement on that says that the work of rigging must be done under the direct and continuing supervision and in the direct employ of a existing holder of the license, which is simply not the case as a matter of law. So whenever at any level of proceedings, whenever a petitioner attacked the idea that they've got well-substantiated experience in a steel yard in Newark, New Jersey, setting up and using 7 cranes to move around steel every day, that this undoubtedly constitutes practical experience in the hoisting and rigging business, which is all that the statute requires, there's just no engaging with that particular idea that experience outside of the city.
Counsel, this is Judge Rodriguez. I have a question for you. Isn't it the case that the Department of Building has interpreted the phrase experience in the hoisting and rigging business to require that the full-time employer be a licensed business? And isn't that interpretation due deference?
They have interpreted it that way, and it is not due deference. They have read that requirement in a practice that was discredited by this court in the Kreitzer case and in several other cases. And again, the idea that the business has to be a licensed rigging business, the statute is 28-404.3.1, requires 5 years of practical experience in the last 7 years in the hoisting and rigging business. Then the department then tries to say that it's unlawful to do rigging work unless such work is performed by or under the direct and continuing supervision of a licensee who then has a licensed rigging business. However, there is that same section of law, which respondents conveniently omit, then says that there is a carve out. It is section 3316.9.1 that says that in lieu of a licensed rigger, the hoisting or lowering of articles on the outside of a building may be performed by or under the supervision of a competent person. And there lists a whole slew of situations. Actually, there are more exceptions than there are the rule. Basically, day in, day out, these folks are doing work that does not require supervision, does not necessarily require a permit, as long as they are competent persons. And the competent person designation is a very lightweight one. We point that out in our papers, that it's basically an ad hoc agreement between essentially the boss and the competent person. And I submit that it speaks to what I would call the respondent's lack of bad faith, that they contest that Mr. Polikoff was a competent person, when, among other things, if you look at his application, he's got a very long list of national credentials issued by the National Crane Accreditation Body. He's got 5 or 6 different credentials. He's a licensed crane operator in New Jersey. So again, the statute says.
Okay, your time is up. I'm going to let you finish your thought there, your sentence.
Yes, I would just, again, I'm reiterating myself, but in answer to this question, it's just not there. The requirement is just not there.
Okay, let's get to your opposing counsel then.
Tahir Sadia, appearing on behalf of the City of New York. The requirement that the practical experience requirement for a master rigger be under the supervision of a licensed master rigger is of longstanding, and the rationality of that requirement is not a new issue. It has been upheld by this court twice, in Marathi v. Hearst, and before that in Orager versus the Department of Consumer Affairs. And there is no showing that there has been any intent to change the license requirement. It remains rational. The language of the statute is that the DOB has interpreted that the language of requiring a practical experience in the rigging business is as work for a licensed rigging business is not an irrational interpretation of the language, and it is in furtherance of the purpose of the requirement, which is to ensure that a licensed applicant has experience performing the kind of work that the license authorizes. And hoisting and rigging work that is exempt from the supervision requirement does not accomplish that purpose. And again, I mean, the department's interpretation of its own rules and regulations is in fact entitled to deference. And this is an area where the Department of Buildings has expertise beyond what a court would have in terms of what is appropriate experience for somebody who is to be licensed as a master rigger. Since plaintiff conceitedly failed to meet this requirement, DOB rationally denied his license. But even setting that requirement aside, plaintiff also failed to show that he had 5 years of full-time experience performing comparable rigging work. His showing that he worked full-time for a steel company and for a real estate company, together with affirmations that he performed hoisting and rigging work for those companies, does not by itself demonstrate full-time rigging experience, as opposed to some hoisting and rigging work along with other duties. And it also does not, demonstrate that the nature of the work that he performed is the kind of work that, similar to what he would be authorized to perform as a master rigger. Some of the exempt hoisting and rigging work, such as moving steel beams from a truck to someplace else in a yard, is not going to be preparation for hoisting objects on the side of multi-story buildings next to occupied streets and sidewalks. So the requirement for contemporaneous documentation in this case was permissible, as within DOB's broad discretion to determine what constitutes satisfactory proof, and it was also rational in that it permits the Department of Buildings to evaluate both the nature and the extent of the rigging work that petitioner actually performed, and to verify the claimed work. I would point out that, while plaintiff takes umbrage at the need to verify, here the truthfulness of plaintiff's representations and of his supervisors are already somewhat problematic in this application, as plaintiff and his TPH supervisor both represented that he worked full-time for TPH, a licensed rigging business, for 3 years, when his wage history demonstrates that that was not actually true.
Thank you very much. Any further questions? Any questions from the bench? Justice Higgett? Oh, okay. Thank you very much.
Thank you.
We're back to you, sir. You're on mute. You're muted.
There's a lot going on here that's just a blatant misrepresentation. Practical experience in the hoisting and rigging business. That is what the statute says. Judge Masley in the first Article 78 pointed out that importing these other requirements from other statutes was done in that this requirement existed in several of the license types issued by DOB. It was not in the one for the master's riggers license. Basic statutory construction, what is left out is meant to be left out. Mischaracterizing Perlin as a steel company as not valid experience. The idea that hoisting steel beams is not practical experience in the hoisting and rigging business is ludicrous on its face. And it goes to the bad faith of this agency. Two things with regard to the agency's discretion or the agency's rationality. Judge Masley talked about the detachment from reviewing the facts.
But counsel, was the supervisor licensed in any jurisdiction in Perlin?
It doesn't matter.
Oh, okay.
It doesn't matter.
Because, on that basis alone, it seems to me, or at least one of the bases, is that they could have found that was, inappropriate, and that would not be irrational or arbitrary or ludicrous, as you put it.
It's not in the statute, and that requirement is in other statutes. There was abundant proof to the effect that he had the experience. There were a total of 5 mutually reinforcing sworn statements that said that he hoisted steel every day. And it is shown in other places that when that requirement is needed, the legislature knew how to put it in. It is simply not there. It is an extra statutory requirement.
Thank you. Thank you both. Leonard versus Sandy Ames.
Have you print out the Bible sheet? So you want me to? Thank you.
Good afternoon, Your Honors.
Good afternoon.
Good afternoon. Steve Anderson for Appellant Dina Leonard. There were no issues of fact on the record below, and the trial court mistakenly denied summary judgment, finding, quote, the record was replete with issues of fact. Appellant and respondent, long divorced, signed a 3-page contract in 2014. They made a deal, and respondent acknowledged there was a deal. She acknowledged that appellant, my client, complied with all conditions. She so testified in depositions. She so stated in emails. And just because she submits a 3-page affidavit on summary judgment, I mean, that simply creates what this court has consistently and continually characterized as a feigned issue of fact. I mean, you don't have an issue of fact because you contradict your own deposition testimony and your own contemporaneous emails at the time. And that's all there is here. I mean, there's not one case cited in respondent's brief on any legal issue, and that's because the law is very clear. And with respect to the facts, respondent admitted that.
Go ahead. Sorry, go ahead.
Respondent admitted that my client paid $70,000 of the universe of $125,000 owing. Respondent admitted in documentation that my client, by her lawyers, said she was ready to pay the rest of the money before the deadline of February 2019.
But it wasn't paid, and there is this back and forth as to whether or not that was where there was a breach, whether the defendant should have accepted the money, whether she anticipatorily breached by not accepting the money, by refusing. I mean, there are issues here that can't be decided in summary judgment.
Well, thank you for raising that, Your Honor. But I don't. That's not consistent, I believe, with the law, particularly on anticipatory repudiation. I mean, like when you have a real estate closing, and if a party says, I'm not going to close title, even though I should, this court and the Second Department in the Soma case has consistently said, well, if you're not going to close title and you tell someone that, and you're not going to comply with your obligations, then a party doesn't have to engage.
You're saying that there was an anticipatory breach because she transferred, I mean, one of your arguments is because she transferred her interest to 380 Lennox.
Your Honor, yes, that is only part of it, though. There were letters and emails from my client, from her real estate lawyer, Teresa Brack, and from me, all saying she's prepared to pay you the $55,000. The agreement says you have to transfer title. Let's close and get it done. And
Counsel,
in fact,
this is Judge Scarpula. Was there anything in the agreement that required her to take early payment?
The agreement said payment by
5 years, over 5 years, right?
The agreement said by February 28.
Did it say, and you must, if I offer you, which I mean, obviously lots of agreements say this, and if I offer you to pay you the whole thing early, you must take it.
The agreement did not explicitly say that.
So she could have, under the agreement, said, I want my 5 years, I'm not taking it now, which is what she did, right?
That's not what she did in the contemporaneous documents. And it's not what she said she did in the deposition, Your Honor.
Well, what did she say she did? She didn't take the money. But we all agree she didn't take the money, and she's not obligated to take it an early payout, right? Because there's nothing in the contract that would require her to take an early payout.
Well, what Your Honor has said that she wasn't obligated, she thought she was. She said at her deposition she was obligated to transfer her interest.
At some point, but the document says what it says, and it doesn't say anything about her having to take early payout. Do we at least agree on that?
I agree with Your Honor saying the words early payout are not in the document.
Well, and that's what you're talking about, right? It wasn't 5 years. She hadn't been paid out over 5 years, had she?
The agreement certainly didn't say you had to wait to February 2019 to get the last payment, Your Honor.
I think that's exactly what it says. It says 5-year payout, and that's, I'm going to pay you here, 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 and here. And if that's what the agreement says, anything else that isn't that agreement, if you don't accept it, isn't necessarily a breach.
Your Honor,
right?
Your Honor, the agreement said we'll pay her over a 5-year period. Now, it didn't specify how many payments had to be made on what date. And Your Honor, most significantly, Justice Scarpula, most significantly, respondent testified at her deposition. She said in contemporaneous documents that she had to accept the money. She understood it that way.
This is a summary judgment motion, and there's right here, these questions are raising issues of fact. So do you have anything else to a different point, perhaps?
I just want to follow up because I know it was Justice Scarpula asked a question, and this is on the same line, because I was under the impression that defendant actually stated that she intended to transfer the property after she received the final payment in accordance with the 2014 agreement, which did not happen.
No, Your Honor. She actually transferred the property in before 2019. She did it several years before, and then she said in her affidavit below that it didn't matter. It was her company, so she had already transferred it. And I'm not banking my entire argument on when it was transferred. Just that even respondent understood that she had the obligation to take the money, and she didn't. I mean, she could have taken the money when the lawsuit was filed. She didn't. I mean, she had an
your
obligation.
6 minutes are up. Let me move to counsel.
Thank you. Good afternoon. May it please the court, Michael Cohen for the defendant. In all candor, you've discussed the issues that I would raise. Is there anything?
Except I have one, counsel, that I want to raise to you. Sure. What factual issue is this, that the agreement itself is the product of fraud, or other than her saying, I felt pressured because I meant I needed money, which, as we know, is seriously not enough. What else have you alleged?
First of all, she said she never got the signed document ever returned to her.
No, I'm talking about, you allege that the agreement was the product of undue influence, fraud, unconscionability, all that. What facts have you pled in support of that conclusion?
You read that, you have the record. Nothing that's going to satisfy you is to.
Well, that's why I'm asking you. So
I know you too. I know you too long.
That's not going anywhere.
No, it's not. That's a very difficult burden on my part, and it's my least good argument to make. She denies the existence of the agreement to begin with. That's fully briefed. She says that all the issues of fact that you've raised. Justice Knock heard argument for over 35 minutes. He had the entire record, and he articulated the issues of fact. The only thing I was going to say in my argument was, it's not like where the trier of fact here articulated a fact that's not in the record, or missed a fact in the record. He looked at the record, articulated the tribal issues of fact, and in all candor, my adversary has sour grapes about it. We should go to trial.
On all of the issues? On all of the issues? You should go to trial on all of the issues, including the fact that the questions that were just asked about the 2014 agreement?
I believe we should go to trial. I believe that summary judgment should be denied and we should just go to trial. I don't think that Justice Knock limited issues. He said there are issues of fact, go to trial. And I think anything more than that would have been dicta. That's just my
Again, I'm just asking you, what issue of fact is there with respect to your claim that this was an unconscionable, procured by fraud agreement?
My client lives with her spouse. Her spouse kicks her out of the house. She then is out of her home and is presented with a take it or leave it deal that my client doesn't know what to do. She then doesn't have.
And she has no attorney. Does she have an attorney representing her?
No, she did not. She didn't. And then she says, and my former spouse never even signed it and sent it back to me. And therefore, she says, I should not be bound by the agreement. Let's go to trial. That's all.
Okay, thank you.
I don't belabor the points. I think you got it.
Thank you. Back to you, Mr. Anderson.
If I may briefly, Your Honors, Ms. Ames, respondent, admitted that she was obligated to transfer her interests. So she understood it that way. I understand how, Your Honors are saying that, that the agreement is not specific by when, but she understood it that way. And all she says in her affidavit completely contradicts what she testified at deposition and what she said in emails. She knew that she was obligated. She knew it was an agreement. She knew she had a transfer title when she got the money. The money was clearly offered. And I think that's anticipatory repudiation under the case law. Thank you, Your Honors.
Thank you both.
Thank you very much. Have a great day, everybody.
Thank you. You're the last argument for the day, and that concludes our arguments here at the Appellate Division. Thank you.